passed. Children with serious behavioral issues could be cared for in a residential or non-residential child therapeutic facility, depending on the results of a social inquiry report and a psychological or psychiatric report. That's instead of being sent to a penal institution, as sometimes happens now. The Bail Act 2023 is to be tabled. Minister of Legal and Constitutional Affairs Marlene Malahoo Ford says the move represents an overhaul of the law on bail after a thorough review, and it reflects consideration of internationally accepted best practices as well as taking into account local realities which we cannot escape. The Constitution Amendment of Sections 96 subsection 1 and 121 subsection 1 Act 2023 is to be tabled and taken. Basically, this bill is to raise retirement age for the Director of Public Prosecution and the Auditor General. Justice Minister Delroy Chuck said the move was necessary as the constitutionally established ceiling for the age of retirement for the Auditor General and the DPP is 5 years shorter when compared with the upper limit for a public officer in the civil service. And that's what's on the agenda. It should be noted that elements of the day's agenda can be changed or moved. But before we go, here are a few things you should bear in mind if you plan to attend a session at Gordon House. No visitor shall create any act of disorder within the precincts of the House. No visitor shall be admitted to the House without first obtaining an admission card. Visitors who remain within the precincts of the House during a suspension of the session are asked to keep silent. No photography, videography, or sketching of the proceedings is allowed unless so authorized by the presiding officer. And there should be no smoking inside the parliamentary building. The proceedings will begin in a few moments.
He is assigned to Central Police Station and is detailed to work at the Supreme Court of Jamaica on King Street, which is where I met him recently. Now, I asked him to join us this morning because he is a prolific letter writer, and he writes letters to all the newspapers. And he has combined his letters. He has a book of poetry, and he has combined his letters that he has written in this volume. It's volume 1, and it's 60 letters to mark the anniversary of the nation's independence, and the topics range from politics to, I can tell that somebody had a large breakfast this morning, you know. But usually when you eat so much, Mr. Brown, you tend to drop asleep. So we're looking for you to fade at about 11:30. The topics range from everything that you can imagine. So I really resisted turning my position into a book club, but I'm going to suggest that you acknowledge him and, if possible, purchase the book, which the Marshal is going to distribute to you. So welcome and thank you very much. So you see, in the midst of despair, there is always hope. So please keep it up, and you come and visit us from time to time, and when you have another volume, don't hesitate to come and see us. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following: Annual Report of the Montego Beach 1975 Limited for the financial year 2014-2015. Annual report on audited financial statements of the Financial Sector Adjustment Company Limited for the year ended March 31, 2022, and its related ministry paper number 72 of 2023 under said title. Annual report on audited financial statements of the Financial Institutions Services Limited for the year ended March 31, 2022, and its related ministry paper number 73 of 2023 under said title. Annual report on audited financial statement of the National Works Agency for the financial year 2015-2016. Annual report on audited financial statements of the Factories Corporation of Jamaica Limited for the financial year 2015-2016. The Casino Gaming Minimum Capital Investment Order 2023 and its resolution under the Casino Gaming Act. The Law Reform Zones of Special Operations, Special Security and Community Development Measures Act 2017. The Law Reform Zones of Special Operations, Special Security and Community Development Measures in respect of the Denham Town Community Zone, the Mount Salem Community and Environs in the Parish of St. James Zone, the Norwood Community in the Parish of St. James Zone, the Parade Gardens Zone, the Savannah Lamar Zone, the Greenwich Town Zone, the August Town Zone, extension of period of operation number 4 orders 2023 and their related resolutions. And also their related ministry papers numbered 74, 75, 76, 77, 78, 79, and 80, respectively, for the period June 14, 2023 to July 13, 2023, giving the social intervention updates. Jamaica Public Bodies second supplementary and revenue of expenditure for the year ending March 2024. The second supplementary estimate for the year ending 2023-2024. The General Consumption Tax Amendment of Schedule Order 2023 and its resolution. Report of the Joint Select Committee to consider and report on the Bail Act 2022. The Auditor General's Special Audit Report of the Passport, Immigration and Citizenship Agency HR practices. The Planning Institute of Jamaica Economic and Social Survey of Jamaica 2022. The Auditor General's Department Certified Appropriation Accounts for Head 20,000 recurring for the Ministry of Finance and the Public Service for the year 2018-2019. Head 20,000 A capital A for Ministry of Finance and the Public Service for the year 2018-2019. And Head 20,000 B capital B Ministry of Finance and the Public Service for the year 2018-2019. Also, Head 4,000 for the Ministry of Labor and Social Security for the year 2009-2010. And the Head 16,049 recurring for Management Institute for National Development for the year 2019-2020. And the Auditor General's Department Performance Audit Report on managing the main road network. Also circulated for your information is the interim report of the Integrity Commission Oversight Committee on its deliberations on the annual report of the Integrity Commission 2022 to 2023.
Thank you, Madam. Bills brought from the Honorable House.
Mr. President, two quick points. The number of these refers to the amount of hard copies, and I think the convention is the the opposition usually gets at least one of the hard copies. Yeah, the mic not working? I'm assured by the marshal that it's working. Maybe I'm speaking too softly. On a number of these announcements of tabling, we have a column to the extreme right that says number of copies, and invariably it has a number of hard copies. I was just asking, we have not actually received any of the hard copies, and I would expect that at least one of the hard copies would be made available to the opposition while the sitting is proceeding.
Yeah, you'll get them shortly.
Right. And
I'm assured that they are in the Parliament.
That's the first point. And the second point, Mr. President, could you give us an update on your awaiting legal advice from the Attorney General's chambers regarding the tabling of the reports of the Integrity Commission in this chamber, and I think it was the Integrity Commission and the Auditor General's reports in the House? Can you give us an update on that?
No.
You have not received the advice?
No.
Thank you.
President, just to clarify, President, the clerk mentioned the Integrity Oversight Committee report. I'm not so sure it's on the long list here, but is that report available to us in the Senate as well?
It's tabled here by way of information, but it's a committee of the House as opposed to a joint.
I appreciate that.
Yeah.
And since it's for information, will we be getting it electronically or will it be circulated as usual?
It's available in hard copy, which will be circulated to you.
I would wish a copy, whichever way it is available. Thank you, President.
Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives. To the Honourable Senate, I have the honour to advise the Honourable Senate that on the 25th day of July, 2023, the following bills were passed in the House of Representatives. 1. An act to repeal and replace the Bail Act and to provide for connected matters. 2. An act to amend the Child Care and Protection Act. And 3. An act to amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General, and for connected matters. Signed, Marissa Dalrymple Philibert, CDMP, Speaker of the House of Representatives.
Mr. President, permission to speak from a seat other than my own. Mr. President, I signify my willingness to take charge of the first two mentioned bills.
A bill shortly entitled the Bail Act 2023, read a first time, and a bill shortly entitled the Child Care and Protection Amendment Act 2023, read a first time.
Mr. President, I beg to give notice of second reading of the bills.
Thank you.
Mr. President, I signify my willingness to take charge of the last mentioned bill.
A bill shortly entitled the Constitution Amendment of Sections 96(1) and 121(1) Act 2023, read a first time.
Mr. President, I beg to give notice of second reading of the bill. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take second reading of the bill and to take it through all its concluding stages.
Thank you very much. Petitions, papers, reports from committees, notices of motions given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the Casino Gaming Act, whereas Section 9(6) of the Casino Gaming Act, hereinafter referred to as the Act, provides that the Minister may, by order, subject to affirmative resolution, amend the amount of the minimum capital investment specified in subsection 3D of the section, and whereas the 17th day of July 2023, the Minister made the Casino Gaming Minimum Capital Investment Order 2023, and whereas it is desirable that the Casino Gaming Minimum Capital Investment Order 2023 be affirmed, now therefore be resolved by this Honourable House as follows. 1. The resolution may be cited as a Casino Gaming Minimum Capital Investment Order 2023 resolution, and 2. The Casino Gaming Minimum Capital Investment Order 2023, which was laid on the table of the Senate on the 28th day of July 2023, is hereby affirmed. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Mr. President, I beg to give notice that the next meeting of the House, I'll move to introduce and to have read a first time a bill shortly entitled the Copyright Amendment Number 2 Act 2023. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take first reading of the bill.
Thank you very much. Questions and answers to questions? Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. Presentation of bills without the leave of the Senate first obtained. Public business.
Presentation.
Oh, I'm sorry. Recommitted. Presentation of bills without the leave of the Senate first obtained.
Mr. President, I now move for the suspension of the standing orders to enable me to take first reading of a bill shortly entitled the Copyright Amendment Number 2 Act 2023.
Thank you very much. Go ahead now. Members would have heard the question. Those in favor? Against?
A bill shortly entitled the Copyright Amendment Number 2 Act 2023, read a first time.
Mr. President, I beg to give notice of the second reading of the bill.
Public business.
Mr. President,
Senator Samuda.
we will take the casino gaming matter first and then into the constitutional matter second. Mr. President, I stand here today to commence the debate in this Honourable Senate of the Casino Gaming Minimum Capital Investment Order, which I will refer to, Mr. President, as the order. The proposed promulgation of this order, Mr. President, is meant to amend the minimum capital investment specified in Section 9(3)(d) of the Casino Gaming Act, which I will refer to as the Act, to decrease the said minimum capital investment required by an applicant from $500 million United States dollars to $450 million United States dollars. This, Mr. President, is to enable Jamaica to benefit from significant foreign direct investment in Jamaica's tourism and casino gaming industries. Mr. President, as this Senate would be aware, Jamaica is being strategically positioned to develop its nascent casino gaming industry as part of our tourism product and offerings. It is for this reason, Mr. President, that the Minister with responsibility for casinos and the gaming industry on a whole is on the cusp of declaring the integrated resort development, which we have spoken on before in this Honourable Senate. However, let me remind the Senate that the grant of the Integrated Resort Development Order is a precursor to the grant of a casino gaming license. Mr. President, the establishment of a fully operational IRD will revolutionize Jamaica's tourism product, and this government is therefore prepared to foster and create an enabling environment within all lawful parameters to ensure the enterprise is a success. And thus, in previous amendments to the Act that was brought to this Honourable Senate, we have sought to remove the unnecessary and onerous legal and financial requirements that stymied the successful establishment of a fully operational IRD. And it is in this vein that we are therefore before this Honourable Senate once again, Mr. President, to reduce the minimum capital investment requirement specified under Section 9(3)(d) of the Act. Mr. President, I will now proceed to do a presentation of the specific provisions of the order. The order is entitled the Casino Gaming Minimum Capital Investment Order 2023. And Mr. President, the enacting provision sets out the authority under which the Minister responsible for finance is empowered to make an order amending the minimum capital investment, which is specified at Section 9(6) of the Act. Paragraph 1 sets out the name and provides that the order is to be read and construed as one with the Casino Gaming Act. And paragraph 2, Mr. President, sets out the amendment at Section 9(3)(d) of the Principal Act, which states the words 500 million is to be deleted and substituted with the words 450 million. Mr. President, in closing, I would just like to reiterate the importance of the government attaches to this matter as we advance development, enhance economic growth, and secure our nation's future. Mr. President, I therefore ask this Honourable Senate to affirm this order and invite contributions from the opposition.
President.
Thank you.
Thank you.
Senator Samuda. Senator Brown.
Let me start by saying that the opposition was consulted by Minister Samuda and the taking of this motion, tabling and taking of this motion today. It's not a controversial motion, and in fact, the opposition have in the past, on both sides of the aisles have, where there's non-controversial issues, agree to table and take same day. That's the responsible approach to be taken in matters that may come before the Senate and the same day requiring suspension of the standing orders. So I wish to commend the approach taken by Senator Samuda, the minister, taking responsibility for bringing this order through the Senate today. We're not going to be opposing the order, which is why we have made it clear to you we don't have any objection to you bringing it today. But not every same day order or bill is going to get the same treatment, especially when there's no consultation. And secondly, when there are fundamental difference of opinion, then such bills should be rushed through. This order is not one such. In respect to the order itself, President, essentially the Ministry of Finance, the government of Jamaica, is reducing the capital requirement for allowing casino gaming of a big time. This is 2023. Senator Braham, I recall driving from St. Ann during the 2008 budget presentation of the then Prime Minister, Bruce Golding. I believe at that time, Senator Webby, you were part of the government in the Ministry of Finance. I'm not going to go to the library to pull Ansard and to say, oh, great a solution, this casino gaming, to which the church and others were opposed, was going to be for Jamaica. It was going to solve the problems in the health sector. It was going to solve a lot of social problems. It was going to create thousands of more rooms in the hotel sector. Jobs for the people, Senator Gale. But that speech, if former Senator Kerensa Morris was here, would say that is a Belmont Road Museum's artifact. That would be a Belmont Road Museum artifact. You don't even know what you have over there, so I forgive you. Point I'm making, President, is that oftentimes we get these glorious pronouncements, but when you put them to the test of time, they are worse than Saddam Hussein Scud missiles. Have no effect. Full of talk. The pipelines are open now, but the Scud missiles have had no effect. And so, oftentimes the government, especially this government, comes and it promises for us prosperity, as the 2008 speech was to have caused the prosperity. Peter Bunting, please don't remind me that prosperity is really a donkey. Please, a jackass. Don't remind me of that, please. Because I don't want to go there. I don't want to say prosperity is a jackass. However, Mr. President, the constant lowering of the capital requirement is some worry, gives some worry. Because what it says is like foreign direct investment. It's not being attracted under this government sufficiently to lift the standard for everybody. And I don't know if this new lower level will attract people. I don't know if this new lower level will attract people, because the premise was 1, 2 casinos. With this lower level, are we expecting more, or is it the same? And is it that these casino magnates have a strong bargaining power that they will get us to constantly lower until we get to zero these requirements? Will our people truly benefit beyond a donkey, a jackass? May it please you, Mr. President.
Mr. President, So, President, do you mind if we take the recommittal just so that before Senator Bunting comes in?
No, it's okay. Senator, hold on.
There's a procedural.
Yeah, go ahead, Mr. Samuda.
Mr. President, should have started public businesses. Mr. President, I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
That is a retroactive. That is a retroactive.
For this casino motion?
Yes. So all in favor? Thank you very much. So it is given retroactively.
Mr. President, I have just a couple of questions for the Minister. I believe one of the projects that was targeted as an integrated casino resort was Harmony Cove. And I assume that that would be facilitated by this lowering of the investment capital threshold. Is that correct, Minister? No, you're not going to answer. You can just nod your head if I'm going on the wrong. If it is not one of those, then I don't. But if since you seem reticent, let me just continue and be more specific. Harmony Cove, as I recall, was a 50-50 venture between the Tavistock Group and the government of Jamaica. We heard, I think just this week, that Joe Lewis, the founder of the Tavistock Group, faces a 19-count indictment with 16 counts of security fraud and 3 counts of conspiracy. Joe Lewis is also the owner, or through his trust, the owner of the Tottenham Hotspur Football Club. But he was charged with orchestrating brazen insider trading by US federal prosecutors on Tuesday. So I'd like to know, Minister, since this has been the principal, this in fact was the flagship and has been the flagship, such anticipated result for a very long time, how will this be affected by these indictments that were brought by US prosecutors this week to our 50-50 partner in the Harmony Cove project?
Thank members for their contribution. And before I ask that the motion be approved, Mr. President, just a few points. Firstly, in response to Senator Brown, the targets and the targeted developments will be announced by the Minister of Finance in very short order. And just to note that we are assured that the investment threshold will be met by these within that same short order. In fact, some are on the cusp of commencing. So that is one. And the public should be aware that certainly, as all the economic indicators have shown, you refer to prosperity as a donkey. And I think it is incredibly condescending of Jamaicans who make particular requests and get them honored by the government. Incredibly condescending of those Jamaicans who tell you what they want and get the support that they need. But beyond that, I'd like to just, Mr. President, can I be heard in silence, please? Thank you, sir. Mr. President, it's also important as we discuss and give the impression to those here and those watching through PBC Jamaica, in whichever mechanism they've chosen to watch, that as we discuss the performance of the economy, the most recent IMF projections project the USA to grow by 1.8%, project Germany to decline by 0.3%, project France to grow by 0.8%. If we look at the BRICS countries, certainly 2.1% in Brazil, 1.5% in Russia, 6.1% in India, and 5.2% in China. But notably, outside of India and China, Jamaica is projected to grow by at least 2.2%. So the country should be aware that there's no question that we're on the road to prosperity. Now, to your earlier question, Senator Bunting, related to the Tavistock group and the matter related to Mr. Joe Lewis. For those also watching here and watching on TV, as you brought up Mr. Lewis's current legal predicament, I think it's important just to remind the public that the deal related to Harmony Cove was signed by the opposition when they were in government. Just to note, that's one. Two, to end the way I started, just to note that the remit of the announcement for which developments will be targeted and how they will be mobilized using the order that is before us, that will be done by the Minister of Finance in very short order. And in that vein, Mr. President, I now move that the motion, notice of which I gave earlier, be approved.
Members should have heard the question. Those in favor? Aye. Against? Minister Samuda, 1 minute. Just before you move on, I want to just recommit announcements. The question is that announcements be recommitted. Those in favor? Aye. Against? Madam Clerk?
This is just to retract the first reading that was made to the Jamaica public bodies. Second was said instead of first, but it is the Jamaica public bodies' first supplementary of revenue and expenditure for the financial year ending March 2024.
What page are we referring to, Ms. Curtis? What page on the announcement? Page 2?
It's
Page. Okay, on page 4, fourth from the bottom, second supplementary estimate. Just for clarification, should be replaced by first supplementary estimate. Thank you.
Thank you very much. Minister Samuda, Senator Sinclair. Senator Sinclair. Senator Sinclair. Senator Samuda.
Mr. President, I now also move for the suspension of the standing orders to enable me to take second reading of a bill entitled An Act to Amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General and for connected matters, and to take it through all its concluding stages.
Premature.
Yes, Senator, there is a motion on the floor. Those in favor?
Yes, I intend to speak on
You
this
want to
motion.
speak on it?
Yes.
Okay, go. Yeah, but I have to ask first of all. Those in favor?
No. No, I intend to speak on the motion to suspend, not on the debate, which will only happen if this motion passes. Thank you for recognizing me, Mr. President. Mr. President, we are on the side of the opposition, object strenuously to this motion. For the good order of this chamber and for Parliament, there is a standing order that says there should be 4 days notice, Standing Order 49-2. That said there should be 4 days notice between tabling the bill and second reading. This is important for all bills, but we have seen where the opposition has not objected to suspending standing orders in case where the bills are maybe relatively uncontroversial or just routine, or maybe there is some urgency required to meet some IMF or other multilateral or bilateral commitment of the government. However, Mr. President, in this case, we think none of those situations apply. In fact, if we speak the truth and we don't attempt to gaslight and insult the people of Jamaica, we will admit that the real purpose of this bill is to extend the tenure of the incumbent Director of Public Prosecutions. There are many reasons why bills should not be rushed. But as a former Attorney General, Senator Brown, you would understand that constitutional amendments, if nothing else, as our supreme law, these should not be rammed through with no notice, all its stages, and done so for the improper purpose of facilitating an individual. The improper purpose. I think it's important, Mr. President, to share with this chamber, that today we have, in my capacity as leader of opposition business in the Senate, jointly with the leader of opposition business in the House, we have instructed Council to write His Excellency, the Governor General, and the Attorney General expressing our concerns with this approach. We have today, you've asked me to repeat it and I will. We, as the leaders of opposition business in the House of Representatives and in the Senate, we have instructed our attorneys to write His Excellency the Governor General and the Attorney General of Jamaica, Mr. Dr. Derek McCoy, to express our grave concerns with the intention to debate and pass this bill in the Senate today after it was rammed through by a majority in the House on July 25th. And we set out the reasons why we have grave reservations. We said there are serious issues, and I'm quoting from the letter. There are serious issues surrounding the provisions of the bill which seek to extend the retirement age for the Director of Public Prosecutions. Sorry?
And not the Auditor General.
No, we know, I mean, since you've raised that red herring, let me just respond to it. The Auditor General is nowhere near retirement age and was introduced just to muddy the waters, because there is no requirement for consultation in the Constitution around the appointment of the Auditor General. So,
Red herring.
so that is just a red herring. So let me go back. There are serious issues surrounding the provisions of the bill which seek to extend the retirement age for the Director of Public Prosecutions. In fact, it is the view of learned counsel, and they have so advised the opposition, that if the legislation is enacted in the present terms, it would breach the provisions of the Constitution in various respects, including because it would be an attempt to circumvent the constitutionally prescribed procedure for the extension of the tenure of a DPP. And worse, the exercise of a constitutional power for an improper purpose. So, Mr. President, we have instructed learned counsel, who has, I would say, an excellent track record against this government in constitutional matters, to file a constitutional claim if the bill is enacted in the present terms. If the legislation is brought into force and implemented pending the determination of that claim, there would likely be considerable uncertainty within the Office of the Director of Public Prosecutions in the period during which the intended amendment would be enforced. In particular, officers who would have been anticipating promotion will potentially face up to 7 more years of the incumbent remaining in office, but with no certainty as to the outcome. A total of 22 years. This may be expected to result in heightened instability and attrition from what is a critical part of the criminal justice system. Given the significant systemic importance of the Office of the Director of Public Prosecutions, you would agree that this would be very undesirable. In the circumstances, our learned counsel invited His Excellency and the government, if they're determined, if the government is determined to ram through this bill, to at least undertake to not assent to or to bring into operation the proposed constitutional amendment with respect to the Director of Public Prosecutions until the determination of the impending litigation. And there's precedent for such an undertaking to be given in these circumstances. The government did so. The government did so pending the constitutional challenges to the legislation seeking to replace the Privy Council with the Caribbean Court of Justice. And we enclose, or learned counsel enclosed for reference, the Privy Council's decision in Independent Jamaica Council for Human Rights and others versus Marshall Burnett and others, and directed their attention to paragraph 2 of the decision delivered by Lord Bingham.
Mr. President, on a
Cornwall.
point of order, if I might. I understood the member.
No,
Senator,
Senator what is the point of order?
I'm happy to
Senator
tell you what the
Bunting,
point of order is.
Senator Bunting, the first thing you'll have to do is to have a seat. And then I will hear.
No, I don't have to. What is the point of order?
Thank you. Go ahead.
Thank you, Mr. President. I understood Senator Bunting to rise to speak on the motion for suspension. Is he now speaking on the motion for suspension or the debate? I want to be clear that he is not seeking to speak on the motion for suspension and again take a position in the debate, because it seems to me that the substance of what he's speaking to breaches Standing Order 43. It is irrelevant to the motion for suspension. May it please you.
Senator Bunting.
That is a nonsense interruption. What I'm speaking to, I am rising to object to the suspension of standing orders. I'm rising to signal that we wish a divide on this, because we believe it is an abuse of the Constitution, something which that side has demonstrated a proclivity to do. And I don't have to go back to the undated letters of resignation of senators. But if you want me to remind you, I will remind you. I'll remind you about the NIDS bill. I will remind you about the number of cases you've lost with respect to the SOEs. So please, this is relevant, because I'm saying we are going to create.
Sorry, Senator Bunting, just continue, because I've ruled on that already. Just continue.
So, So I have set out, Mr. President, the contents. I have set out the contents of the letter from Learned Counsel on behalf of the leaders of opposition business in both houses.
Colleagues on this side, don't entertain.
But, Mr. President, I am supported and buttressed in this view by no less a voice than the Senior Deputy Director of Public Prosecutions, who has written to the Prime Minister and who has copied opposition members, leader of the opposition, and the President of the Senate on this letter. We have verified it with the person to confirm its authenticity. And the concluding paragraph of that letter says, in the circumstances, I ask for the postponement of any further vote on this amendment and the launching of an investigation into the viability of the office. That is the Office of the Director of Public Prosecutions. If this is done, I am certain that you will find that there are serious issues to be addressed, which may warrant a conclusion that the proposed amendment should not be effected at this time in respect of the Office of the Director of Public Prosecutions, if at all. If at all. This is written by the second most senior officer in the Office of the Director of Public Prosecutions. And there is a lot of content in there. And if the government, if the executive, if the leader of opposition, the leader of government business rather in the Senate, insists on ramming this through today in the same way, then we will go into all the content of it. And the risk of that, Mr. President, is that this very important constitutional office will henceforth be completely tainted and appear to be bipartisan based on the approach of the government to bring this constitutional amendment bill purely to facilitate one individual who is in office, who they seem to have some unseeming interest in them continuing in office. And we therefore
on a point of order, that is ascribing motive to actions, Prime Minister must, President, and that must be withdrawn.
I said there
Senator Bunting,
ascribe motive, that is a breach of the standing orders, withdraw the comment and move on.
Senator Bunting, I believe I want to uphold.
Okay,
I'm upholding that, and I'm asking.
I withdraw it, but I would instead ask, what is the motive? What is the motive? Why you want to abuse the Constitution in this way? What other legitimate motive? I'm going to enumerate them. They're well enumerated in this letter and in various letters, and in the substantive debate, they will be enumerated. And I think it's unfortunate that you have insisted, the government side has insisted with this unseemly act in bringing all the dirty laundry out into the public to be washed. And it's going to injure that important constitutional office. Thank you, Mr. President.
Senator Morris.
Thank you, Mr. President, and I rise to make my intervention on this motion seeking permission to suspend the standing orders to facilitate the debate on this bill. And I do so, Mr. President, as a member of this chamber who has been charged with the responsibility to uphold and defend the Constitution and laws of Jamaica. And I have said on every occasion that I get in this chamber that I take the oath of allegiance very seriously. And I take the Constitution of Jamaica very, very seriously. Because the Constitution of any country, especially in a democratic state, in a democratic state, is a very serious, serious instrument. It is regarded as the supreme law of the land. And therefore, if you examine the historical amendments to our Constitution over the years, you will notice that extensive consultations have been made, irrespective of disagreements. Extensive consultations have been made on different issues relating to changes. And it is deliberate because of the fundamental nature of the Constitution. And so I was very shocked, like other members of the opposition and members of civil society, when a bill was brought to the other place, like Nicodemus, and debated overnight without any due regard for the people of Jamaica and the opposition who have been elected and sworn in the parliament to defend the Constitution and the people of Jamaica.
The agenda changed 4 times. The agenda for the House
And,
changed 4 times.
you know, Mr. President, when I see these things happening with this sort of frequency that is taking place in this parliament, it gives me concern. And that is why, as you look through social media and you listen to the conversations taking place in traditional media, the constant thread that is running amongst the people and the persistent question that is being asked is, are we bordering on an autocratic state? Are we bordering on a totalitarian state? I make sure I keep out of these places that you are in, you know. I keep in civil places. But, Mr. President, as I listen to the conversations on this matter in the public space, it gives me great concern because the Jamaican people endorses, the Jamaican people embraces the Constitution of Jamaica. So they don't want no government to come overnight and amend their Constitution without consultation.
That's what they've been asking for.
No changes to their Constitution without consultation. And it borders on hypocrisy where this government is concerned. Because I know previously they have insisted that the people must be consulted on any changes that is being made to the Constitution. Don't worry about me, man. Ask Minister Samuda every morning. Every morning him see me busy walking on the road. So don't worry about me.
You're a senior.
Yes.
Don't deal with
When you say political neophytes.
Don't deal with the neophytes.
Yes.
Ignore the penny section.
Yes. So, Mr. President, I am very much concerned about this motion that is being placed before us to seek leave to get permission to debate the Constitution and fundamental change to the supreme law of the land. And, you know, Mr. President, as I listen to the discussion in the public spaces, I heard my mentor and friend, Professor Trevor Monroe, who I work with. You can't walk in Trevor Monroe's shoes no day of your life. No day, no time. So don't pass your place. Don't pass your place. No day, no time. You can't walk in Trevor Monroe's shoes. So I heard Professor Trevor Monroe and I heard Dr. Lloyd Barnett, eminently qualified individuals, to discuss the issue of constitutional law. And as I heard them speaking publicly, I said we need to make sure that we have time to evaluate the issues and the implications of this legislation. And because of my commitment to defending and upholding the Constitution and law of Jamaica, that oath that I affirmed, I am making a reasonable request to you, Mr. President. I'm making a reasonable request and accommodation to you for this debate not to proceed today, and that the Senate be given the opportunity to examine the bill as required by the standing order to be tabled, and for us to get sufficient time to examine the constitutionality of it. And I am making a specific and deliberate request to you, Mr. President. I'm making a specific and deliberate request to you for reasonable accommodation to be made, not just for myself as an individual who just get the bill 2 days ago and have to have time to look at the Constitution and all other documents relating to this amendment. I would want to get sufficient time to do and execute my constitutional responsibility. And I am leaving it in your hands, Mr. President. Your hands, where this request is concerned. May it please you, Mr. President.
All right. I think they have one other speaker. I'm seeing Senator Brown gesticulating that he wishes to speak. Go ahead, Senator Brown.
President, President, this motion is to suspend Standing Order 49-2. Colleagues, can I ask you on our side not to comment on the attempted destruction on that side? Because we shall be heard in silence. President, I repeat. That's fine. This motion we're debating is to suspend Standing Order 49-2. The people of Jamaica need to know what that standing order says. And let me quote, an interval of not less than 4 days shall elapse between the first and second reading of a bill, unless the Senate on motion made and question put agree to proceed with the bill at an earlier date or forthwith. So the proviso does allow a majority to change the standing orders. But we should not be in a rush to change the standing orders. Because there's a reason.
It's not changing the standing order.
To
Standing order is there.
To suspend it.
It's there.
To change it for this bill. That's the effect of the suspension. To change it for this bill is the effect.
Changing it, Senator Brown.
To change it
Senator
for this
Brown,
bill
Senator
is the
Brown,
effect of
Senator
the
Brown,
suspension.
no, the standing order actually says, and you read it, unless the Senate on motion made and question put agree to proceed with the bill at an earlier date or forthwith. So the standing order speaks to it. It's not changing anything.
Let us be clear. The postponement of this bill laying here for 4 days between first and second reading means that we're changing the normal approach to bills. That's the point I'm making. And is this bill worthy of such a postponement? It is my view that contrary to what my friend, who has 2 cases in the Supreme Court to answer to, wishes to say.
Don't go down that road now, Senator Brown, please. Please.
He has said yes.
Senator Brown, please do not go down
Which
that
road am I going down?
You are referring to a matter that is presently before.
But I'm not doing so in a manner that will prejudice the decision.
I'm asking you not to go down that road.
Yeah, and I'm saying to you, I'm not doing so in a manner.
I have Senator Brown. Senator Brown.
Let me say, Senator Ila said yes. I said no.
Senator Brown, please, just don't go down that road.
I am very focused. He has said, Senator Ila said yes to the postponement. I am saying no. And I am saying I have no case in the Supreme Court. I won't go any further than that. I am saying, sir, I have the time, you know, so they can interrupt as long as they want. President, this bill is a constitutional amendment. The Constitution is not Mark Golding's Constitution. It's not Andrew Owen's Constitution. It is the Constitution governing the people of Jamaica. We do a disservice to the people when we rush a constitutional amendment without allowing the people a chance to assess the merits or demerits of the constitutional amendment. The other place on Tuesday, the majority took a decision. It comes to us because of that. And with the court saying that senators have an independent view, I bring my independent view to this debate about postponing or suspending the standing orders. Mr. President, constitutional amendments should not be for a individual or 2 individuals. Constitutional amendment must be about principles of governance in the interest of the broad society. This amendment which we are trying to debate today, doesn't mean that this amendment fits in with doing something for an individual or two individuals. Depends on how you see it. Mr. President, I vote against rushing this bill today. I will vote against it, and as Senator Bunting pointed out, we will take a divide. Mr. President, 4 days would give us a chance to debate this next week, Friday, just before our Independence Day. This is often called an independent constitution. And the 4 days would give us Friday, more than 4 days. Friday would give us more than 4 days. Thursday, if you want. Thursday would be fitting in the 4 days. Wednesday would be fitting in the 4th day. However, Tuesday, Emancipation Day, is a public holiday. But the Monday before that, which is the 31st, would not fit within the 4 days. But, Mr. President, I am opposing this motion because it is well known that on Monday, the 31st of July, the full court of the Supreme Court, 3 judges sitting, are scheduled to hand down a judgment in a matter.
Senator Brown.
Don't tell me about Senator Brown. Nothing. I am not abusing the standing orders.
Well, I am going to say that you are. So I'm just asking you to
can say it 1,000 times, President.
Your saying so does not make it true, Mr. President. He's making a reference to the calendar. He's making a reference to the calendar of the Supreme Court.
Senator Bunting, both of you can't stand at the same time.
Come back, Mr. Dow.
Senator Bunting. All right.
Both sit down. Come back, me sit down. You come back, me sit down.
Senator Bunting.
Right? Mr. President, the Senator is making a reference to the calendar of the Supreme Court.
I'm not going to have any discussion about what is in the Supreme Court.
He's making
or any ruling that is proposed to be in the Supreme Court.
He's making a reference to the calendar.
And I am saying
that is not in any way prejudicing a case that is before the court.
Okay, well, I have ruled. Senator Brown, just stay away from what matters are before the Supreme Court, please.
President, I am faithful to the standing orders of this Parliament. I am faithful to the standing order.
You are faithful to the standing order, Senator Brown, and I have made a ruling. I am asking you to proceed without making any commentary to any matter that is before the Supreme Court.
President.
So be faithful to the standing order.
President, you must not discuss a case. President, you must not discuss a case with a way to influence the case. I have no way of influencing a decision. That is, on the 31st, Monday coming, the Supreme Court
Senator Brown
is due to hand down a decision
Senator Brown
relative
Senator Brown
to this matter.
Senator Brown.
Yeah?
Senator Brown. Please. Please.
President, on the 31st, Monday coming,
let me ask you a question.
The Supreme Court is due to hand down a decision.
You know what is in that decision?
I am not.
Why are you discussing it?
I am not interested in what the decision is.
Senator Brown, I am asking you to leave that out of your conversation.
No.
This is the last time I'm going to say it.
Let me continue. President, all I am doing is repeating what has been carried publicly in the Gleaner on the 14th of July, that the full court will hand down a decision on Monday.
Good. Okay. Move on now, Senator Brown, please.
So, Mr. President, given that a decision is due on Monday down King Street. I believe the suspension of the standing order today ought not to be agreed. I believe the suspension of the standing order today ought not to be agreed to. And we as senators should allow the co-equal branch, the judiciary, to make their pronouncement on Monday. The Gleaner carried that story, headline Paula's D-Day, that on the 14th,
Senator Brown,
on the 14th of July.
Senator Brown.
My position is don't rush this bill. Allow for the people to have a say. Allow for the senators to be able to consult with the citizens. Allow us to exercise our independence in an informed manner. I say, don't rush this bill. I will vote no, and those opposition senators present will divide to show to the country that the 7 House present, because Senator Allen is abroad with official business, the 7 of us present will vote no against this postponement of the standing orders. We will also divide so the country will know by name who voted for and who voted against what to me is an abuse of the parliamentary process. It's an abuse of the Constitution, and that I, like the rest of you, swore that we will uphold the Constitution and laws of Jamaica. Mr. President, those who are willing to play politics with the Constitution ought not to be allowed so to do. And if they insist on doing it, we in opposition representing the people of Jamaica who have not been consulted will stand with the people of Jamaica and say that this is an abuse. Allow the standing orders to run its course. Do not suspend it. Don't rush this bill. May it please you, Mr. President, as I await Monday's decision of the full court of the Supreme
Senator
Court
Brown.
in this matter. You can shut me down on that, but Monday coming is like pregnancy.
Okay. Senator Brown, thank you. Thank you. Now, you know, sometimes I hear words that are used in the Senate, and I don't want this platform to be used to mislead the Jamaican public. Because to say that there is an abuse, to use a word as I am making a comment, Senator Bunting.
No, Mr. President.
It is not an abuse. It is not an abuse.
You are an impartial presiding officer.
And all I am doing is bringing some edification to the persons who may be looking
you are
on.
participating in the debate.
I am not participating in anything.
We have seen enough abuse
Senator Bunting,
Senator
Bunting, I am speaking. Can you have a seat?
I really ask you to desist from this.
Senator Bunting, can you have a seat? Can you have a seat, please? Can you have a seat? Thank you. The standing orders of the Jamaica Senate facilitates under Standing Order 49-2 appointment of days for stages of bills. And it reads that an interval of not less than 4 days shall elapse between the first and second reading of a bill unless the Senate, on motion, made and question put, agree to proceed with the bill at an earlier date or forthwith. So there is a process, and there is no abuse because it is written and there's a literal interpretation of it. And if the Senate agrees that it is proceeding in one way or the other, that is facilitated, not an abuse. And if you also read the Jamaica Constitution, and in particular Section 55, I believe it is, of the Jamaica Constitution, then it facilitates the procedures that takes place in here and in Parliament in relation to bills and motions. So, where we are, there's a motion that is put by Minister Samuda to suspend the standing orders to facilitate him taking a bill today. And I so put that motion. Those in favor? Those in favor? Divide. Thank you. Madam Clerk. And just so that the Jamaica public knows too, that a divide is facilitated under the standing orders, where the votes of each person will be taken individually by name. Thank you. Can you proceed, Madam Clerk?
Senator Allen, Senator Braham, Senator Bunting, no. Senator Brown, no. Senator Crawford, no. Senator Fitzhenley, yes. Senator Fraser-Beans, Senator Gale, yes. Senator Golding Campbell,
yes.
Senator Hill,
yes.
Senator Johnson Smith, Dr. Longmore, yes. Dr. Morris, one Dr. Morris here.
There is supposed to be independence in this, Senator Brown, so leave Senator Morris alone.
Dr. Morris? Dr. Dixon? Dr. Sorry. Yes. Dr. Morris. Dr. Morris. And then Senator Gabriela Morris. Mr. Samuda. Senator Scott Motley. Senator Scott Motley? No. Senator Webby? Yes. Senator Williams? Everybody? Should be Dr.
All right, I have the result of the divide as follows, that yes, 10, noes, no, the ayes have it. Minister Samuda, just before you proceed, I wish to identify, sitting in the well with us, the Honorable Pernell Charles Sr. Pernell Charles Jr. has left. Former Member of Parliament Minister of Government and Speaker of the House of Parliament. Welcome, Purnell. All right, Minister Samuda, proceed.
Indeed. Thank you, Mr. President. Mr. President, the Constitution of Jamaica establishes a retirement age of 60 for the position of Auditor General and Director of Public Prosecutions via Sections 96(1) and 121(1) respectively. President, the Pensions Public Service Act, which was promulgated in 2017, sought to, among other things, gradually increase the retirement age of public officers to 65. The bill before this Honourable Senate, Mr. President, reflects a proposal previously considered by Cabinet during the deliberations on the Pensions Bill in 2016 and 2017. It was the intention of the government to amend the Constitution to give effect to the change in the age of retirement for officers so as to extend the increase in retirement age to both the Auditor General and the Director of Public Prosecutions. Mr. President, as is evident, this was due mainly to the fact that the constitutionally established ceiling for that age for the retirement of the Auditor General and the DPP is actually 5 years shorter in duration when compared to the upper limit set in the Pensions Public Service Act for a public officer in the civil service, and indeed 10 years shorter than that of a High Court judge and a judge on the Court of Appeal. Mr. President, in fact, colleagues should recall that the raising of the retirement age for judges in the High Court and indeed the Court of Appeal was considered and supported by members currently sitting in this chamber. Well, Mr. President, proposed amendments to the Constitution will allow for the expansion of the term of service from 60 to 65 years, thereby addressing the inconsistency that currently exists between the two pieces of legislation and by extension creating a more level playing field for all. Mr. President, it will even address the inconsistency, and those watching here and at home, the inconsistency that has arisen from us as members of a review chamber that reviews laws who are indeed over the same age that we are increasing for the DPP in this chamber. But we'll come to that later. Mr. President, the framers, a man, for instance, who is 62 years old, objects to the increase of the age of the DPP from 60. A man who reviews the laws, that if there is an abuse of those laws, the person who prosecutes it must be less. We will come to that though, Mr. President. All in due time. All in due time. You know, Mr. President, the framers of the Constitution anticipated that the age of retirement can change. It is the reason that it is not deeply entrenched. It is a simple amendment that should be supported by all, despite the brouhaha. Mr. President, I will highlight the main features of the bill, the Constitution Amendment, Sections 96(1) and 121(1), 2023. Clause 1, it treats with the short title and construction. Clause 2, Mr. President, amends Section 96(1) of the Constitution by removing the words 60 years and substituting instead the words 65 years. Additionally, the clause deletes the words not exceeding 65 years in paragraph B and Section 96(1) and substitutes the words not exceeding 70 years. These amendments raise the age of retirement to 65 years and allow the Governor General in appropriate cases to permit an extension up to 70 years. The clause goes on to allow a sitting DPP at the date of the commencement of this amendment to the Constitution to elect in writing to the Governor General to retire at any time after attaining the age 60 years. Clause 3, Mr. President, amends Section 121(1) of the Constitution by removing the words 60 years and substituting instead the word 65 years. Additionally, the clause deletes the words not exceeding 65 years in paragraph B of section 121.1 and substitutes the words not exceeding 70 years. The clause goes on to allow the sitting Auditor General and the date of the commencement of, at the date of the commencement of this amendment to the Constitution to elect in writing to the Governor General to retire at any time after attaining the age 60 years. Mr. President, this ends the clause by clause section of this discussion, of the debate, and where I will invite members to contribute to the debate on this constitutional motion. I look forward to reminding them at a later time of what they would have said during the debate on the extension of the retirement age for judges in the Court of Appeal and indeed the High Court judges. Well, Mr. President, I look forward to the debate and I look forward to my closing. Thank you.
Thank you, Minister Samula. Senator Scott Motley.
Madam, may I? I'll take this one. Thank you.
I hope that they will learn that the feet of the billion.
Mr. President, this is a constitutional amendment that we are debating here.
We need to hear her clearly.
And I would like to believe that in spite of the utterances that every single member of the Senate takes the Constitution seriously, respects, and has high regard for it. It was just about a month or less, slightly more, I don't recall the date, on which Senator Morris Dixon and Senator Abka Fitzhenley took that oath. And they did it with extreme solemnity. Senator Fitzhenley didn't even have to read it. He was so familiar with the oath that he did not make reference to the actual document being placed before him. And I would like to think that there is going to be some deep consideration given to why we are here and what the opposition is saying. Indeed, I recall when we were debating an extension to the state of emergency, and apparently Senator Don Webby found me so audacious to have indicated in an interview prior to the debate on the matter. He felt that I'd crossed every single line in indicating how the opposition was likely to vote. I have never before seen him so angry. I have never seen him so angry since.
You were absolved by the court.
And I would like to believe that across there, Senator Webby's words, which he used on that occasion, will resonate. And that there might be even one person who is open to persuasion on a point which is of constitutional importance. So let us look first at the amendment in regard to the Auditor General. That amendment is at section 121 of the Constitution. And it says that subject to the provisions of subsection 3 to 6 inclusive of this section, the Auditor General shall hold office until he attains the age of 60 years, provided that he may at any time resign his office. I have to be faithful to what the Constitution reads as. And B, the Governor General, acting in the manner prescribed by subsection 6 of section 120 of this Constitution, may permit an Auditor General who has attained the age of 60 years to remain in office until he has reached such later age, not exceeding 65 years, as may, before the Auditor General has reached the age of 60 years, have been agreed between the Governor General and the Auditor General. What? So we are clear that this constitutional amendment does not directly, at this moment, address the tenure of the Auditor General.
No urgency in that regard.
We are clear that there is no consultation required between the opposition and the Governor General, or any consultation required with any party according to how the section is framed. On the other hand, section 96(1) makes it clear that the Director of Public Prosecutions should hold office until he attains the age of 60 years. And again, he may resign the office at any time. But it goes on to say, the Governor General, acting on recommendation of the Prime Minister, after consultation with the Leader of Opposition, may permit a Director of Public Prosecutions who has attained the age of 60 years to continue in office until he has attained such later age, not exceeding 65 years, as may, before the Director of Public Prosecutions has attained the age of 60 years, have been agreed between them. So there's a totally different process. And it is important that we understand what has obtained in this case. Because in 2020, prior to this DPP attaining the age of 60 years, she applied for an extension of 5 years. That is to say, she asked to be allowed to continue in office until she reached the age of 65. The consultations took place, and the Governor General extended her term of office for 3 years until she attained the age of 63, which she will do in September 2023. And all of this, Mr. President, is around that provision. There has been much debate in legal circles and in the public as to whether the DPP could get a second extension of her tenure. Because it was clear from the mutterings and the utterings that the government desired to give the DPP a second extension of her tenure. And I do believe the weight of legal opinion came down on an interpretation of 96(1), which was that only one extension could be granted. This bill, this constitutional amendment to 96(1) and to 121 is designed to circumvent section 96(1).
Improper purpose.
It is designed to give the Director of Public Prosecutions an extension of her tenure because it could not legally be done under 96(1). That is, let's forget about all the static in the environment. the static in the atmosphere, I must quote accurately. That is what it is about. The government wishes the DPP to extend their tenure, and they have found a way in which they can legitimately, in the sense of the fact that 96(1) is not an entrenched provision, so they can come now with a simple majority.
You don't understand improper purposes. You don't understand that. Improper purposes.
So let us understand what has taken place. The government has avoided, the government has deliberately avoided any need for consultation in this matter. The government has rammed through this provision simply because it can, because it has a majority in the House. The government has elected to turn its back on well-known conventions and principles which speak to good governance in order to have this legislation passed. And I will say this, the legislation was not drafted last week, Friday. It was not drafted Monday morning. This had been in train for months. There was every opportunity to have consulted with the opposition on this matter. But with stealth, the government brought this to the Parliament on Tuesday. The agenda for the House was changed on 3 occasions, if not more. Because it seemed as though there were people in the government who sensed that what they were doing was morally wrong.
The Minister of Justice himself is a little confused.
It seemed as if there were those on that side, Senator Webby, who had a moment when their conscience would have said, this is not how you do it. It is wrong. And I speak within the context also as a member of the Constitutional Reform Committee, where we got terms of reference and where it was clear that these matters had to be addressed in the constitutional reform process. This matter was never brought before the committee, although it has been in the offing for months.
What?
So we were sitting there at Jamaica House, sometimes twice per week, methodically and systematically going through what needed to be done for constitutional reform, Senator Braham.
Speaks to the sincerity. Speaks to the lack of sincerity of the government.
Devising consultation methodologies so that the people's voices could be heard, as the people said they wanted their voice to be heard. Going off or having town hall meetings online so that people could have the opportunity to participate and to understand what a constitution is, that this supreme document affects their lives. And they were being invited to participate in what was called the repatriation of the Jamaica Constitution at the outset by the government. Not one single word. Not one single word to the committee. Not one single word to the country. And this issue, this amendment of 96(1), begs the country to observe and to conclude on whether the government is sincere about the reform process or is just a sham. Is it just a sham? Can this government really be trusted when it speaks on these matters? Because if it had not been a sham, would not even the mention be made at the committee level? Wouldn't the committee be asked to opine as to whether this is a matter to be brought forward from phase 3 and brought to the public immediately? But no, no, because there was no intention for that. This was only designed to circumvent the Constitution. That's all. It's so clear. And Senator Graham, if this process could be adopted in this cavalier and callous way, this contemptuous way, this contempt for the people, this contempt for the process, then am I supposed to believe when the government tells me that they are serious and sincere about the entire process of constitutional reform, and that they're really asking all of us at the table to craft a path forward? Or is it just that I'm going to the office of the Prime Minister for 2 days per week, all day from 9:30 until 4:56? Because for some strange reason, the minutes will show you that they end at 4:56.
Every time?
The implications for democracy are significant. They are enormous. And I tell this government that they have brought the office of the DPP into disrepute by the way that they have approached it. This Nicodemus-style way of bringing this matter to the Parliament, the last available sitting, suggests that there must be some significant reason why this matter had to be run through. And now, this DPP, who has been praised for her competence and her courage, must now face public questioning and challenging and scrutiny in a way she never did because of what this government has done. Why have you subjected the office of the DPP to public opprobrium?
Why?
What is it that is causing that this decision be made?
In the state of Denmark.
I had to wait until Senator Samuda returned here to make the point that I am not for a moment being critical of an increase in the age of retirement.
That's another ready.
Not at all.
That's another ready.
And I am deeply disappointed because I have very high regard for Senator Samuda, not just his intellect, but his integrity. I am deeply disappointed that he has taken this very snide and cynical approach to what the opposition is doing.
Wait until the closing, then you will see what is worse.
That is worse.
Indeed, there are many public officers who have sent me messages to say, will you advocate for us to be able to go to 70 if we want? Will you advocate on our behalf? Because there are some of us who would like to do so. And I can speak as somebody who makes no claim to youth, and I'm quite proud of my mature age. I hope that with it has come some wisdom and some experience. I believe that people can serve far beyond the age that has been dictated in legislation. I am one of those persons who offer myself quite willingly, and I dare say sometimes work harder than those people who have been vested with the authority to do so, because I work diligently as far as is possible as somebody who also has a profession with my parliamentary work. So let me make it clear, Senator Samuda, this is not a matter of somebody who is old, 2 years beyond the age of retirement, as you had mentioned, opposing an extension to 70.
Ageism? No, rubbish. Rubbish. You don't understand it, Matthew. I thought because ageism you're arguing. No, shame, man.
That's a diversion. Don't insult the public. Don't insult the public with that rubbish.
That if you are over 60, you
well know it. BS. You well know this is BS.
And the public is listening. And the public is judging. And the public will take note that even today, the Minister of Justice had to withdraw some remarks he made when he opened the debate. And the public is also taking note that we have a Minister of Legal and Constitutional Affairs who did not pilot this amendment to the Constitution. Although her main office, her main responsibility is for matters of constitutional affairs as stated by the Prime Minister when he did his cabinet reshuffle. And there are those who are taking note of the fact that the Minister of Justice claimed that it was like a dusting off why he brought this matter. But I return to where I started. An extension was granted to the Director of Public Prosecutions in 2020. At that time, the Pensions Public Service Act of 2017 was in effect. There was no attempt by the government then to signal a desire or any interest in increasing the age of retirement. That would have been an appropriate time to do so. If it had been overlooked at that time, then there were 3 more years to make that change. We could have had discussions. We could have determined whether for certain offices we should have fixed terms so that we don't find ourselves in a conundrum that somebody is in office for 22 years or 30 years or 40 years. Senator Braham was a member of the General Legal Council when we had an intense debate about matters such as this, and when we decided that the best practice was not to do anything which would cause an office holder to believe that their efforts and their service was not appreciated, but to simply have a limit on when they could serve. We could have spoken about that. We could have discussed behind closed doors all the principles which are being now fully ventilated in the public space. And we could have worked it through and come to this Parliament, to the public, to those persons who are now familiarizing themselves with the Constitution because they want to have a say in the kind of governance which we have in this country. We could have presented a united opposition and government so that some insight could be gained into how a parliamentary democracy could work. When the government and the opposition see a matter as so fundamental and so critical that they come here on the same page. This government, in acting as it has done, trying to avoid the provisions of the Constitution, will find that they will have to answer to it. There is no question about the fact that some issues, some very critical issues have been raised. And in a way, as an attorney, I always embrace when there's a challenge to legislation, because I remember in the Needs case, when the Chief Justice said there are many things that are done which are unconstitutional, but we will not know that until it is brought to the court, yes, and the court rules on it. I believe this is a matter, on which the court should rule. I believe that Section 96(1) needs to be fully and thoroughly examined in the court. I believe that one should understand why Section 96(1) is not entrenched, but all the other sections are entrenched. And a bill to amend any other section has to be tabled for 3 months before it is debated, and has to remain for another 3 months before the Governor General can get a send. And we need to examine the spirit of the Constitution to see what was intended by the framers. I caution that the Constitution should not be tampered with. I caution that the Constitution should not be amended willy-nilly. That especially after the government has committed to a process of constitutional reform. And more importantly than anything else, engage the people in the conversation that this is a wrong thing to do. And I want to say one final thing which might be a little unexpected. I do not doubt the sincerity and the commitment of the Minister of Legal and Constitutional Affairs. I have seen how she works. I know that she wants this process to go through.
That's why she had nothing to do with this bill.
I see how much she has accommodated discussions and how the entire committee has worked so hard to arrive at consensus in a respectable way, respect for each other. But I don't think the government is supporting her. I don't think the Prime Minister and the rest of the team gives her any support.
No sincerity.
None.
And this is indicative of that.
No sincerity.
And this action on the part of the government is the clearest signal to the people of Jamaica that the government is insincere and is not speaking the truth about the fact that they want to see any changes.
Mr. President.
Thank you, Senator Scott Motley.
Well, I thought you would have said that. Nevertheless, Mr. President.
Thank you. Senator Brown, come now, man. Senator Brown. Well, when you get a chance to make your contribution, you can ask it. Senator Graham.
So the question
Senator Fraser-Binns
that I ask myself is whether or not the proposed amendments, Mr. President, are in keeping with the Constitution. Well, there you have it. I suppose I'll have to go down here. Anyhow, let's see how that works. I won't be long, so. Thank you. So the question is whether the proposed amendments being placed before the Senate today is in keeping with the provisions of the Constitution.
You know, Senator Brown, I'm going to understand. Hansard, are you hearing Senator Brown? All right, so what I'm going to add, members might be interested to know that as of Saturday of this week, we're going to start to rewire the chamber for audio, for audio refit. So until that time, you have to just, that's better, Senator Brown?
Is it? Well, let's see. Are you hearing me then? Is it any better? was asking, Mr. President, whether the proposed amendments are in keeping with the Constitution itself in terms of the words of the Constitution. And I believe that I have heard some slight concession that the proposed amendments are in keeping with the provisions of the Constitution as they are read. In other words, Section 96 and the other section, Mr. President, do make provisions for the amendment of the age requirements in the Constitution in relation to these two officers. And that is clear and without doubt. The section, unlike other sections, Mr. President, do not make provisions for any delay laying on the table of the Senate or the House for 3 months and then another 3 months. It does not make any provisions for any delay. And that's a fact, it does not. Other sections do. And you see, we can't have our cake and eat it. At least it's very difficult because the Constitution, in one hand, provides for delay, consultation, and in other cases, it does not. So then, if the Constitution is followed, Mr. President, then it cannot be suggested that following the process set out in the Constitution is illegitimate or unlawful. Because if you do what it says, then doing what it says under no circumstances can be declared to be unlawful. And what it says, that if you wish to change the age of the incumbent or any person occupying the position, you bring a regular bill to the House and the Senate, and it is passed in the regular way. And the usual standing orders of the Senate and the House would apply. That having been done, then it is a bit insincere to go around to say that it is illegal or unconstitutional, or it is an abuse of process. So my own position, Mr. President, is that I'm satisfied on the face of it that the document, the amendment is in keeping with the Constitution, and that is a legitimate act insofar as the Constitution is concerned, and therefore there's no reason to prevent these bills from going through. There's no reason. There is another provision in the Constitution, because it appears that the framers themselves demonstrated some care as to what the age of these incumbents ought to be. And they did provide initially at 60, and that you could extend it to 65, etc., etc. But that's a separate regime. It's an entirely separate regime. It does not affect the amendment regime. And if you impose one as against the other, it does not detract from the use of one as against the other. So, Mr. President, applying the Constitution and following the Constitution, there is no reason to feel that one is acting outside of the Constitution. And of course, I know that the courts are available to give decisions, and that it is the right of every citizen, including those in this Senate, to approach the court. And the court will answer as they wish. And according to law, we will comply, no doubt, with whatever the court says. But as it stands here today, Mr. President, with all the speech making and so on, it seems to me that the Senate, if it's thought fit, can proceed to act in accordance with the Constitution. No one has said that they are not acting in accordance with the Constitution. So if you are complying with the Constitution, how then can you be said to be immoral and have all sorts of other insinuations made? How then can it be said? if you're acting in accordance with the Constitution. And so, having agreed that we are acting in accordance with the Constitution, it seems that that argument, as one other person would say, basically done. The Constitution speaks, you act in accordance with it, and that is the end of the matter.
Thank you, Senator Bram.
Leave it here. Unless, Fly, you want to go?
Senator Bram just spoke.
Oh, sorry. President.
You were so moderate, you didn't think that you...
President.
Senator Brown.
I just wish to mark the day in which I rise in history. That it is a day that the full court has decided that judges were not biased in a certain case that is to go to trial for fraud. I wish to mark this day that I rise on this constitutional amendment to say I have confidence in the judiciary, who is due to make a judgment on Monday on a matter touching upon the Constitution. I have no interest in whether the outcome, I know not where the outcome will be, but I know as a mark of history that in 3 days' time, judges will pronounce from the full court. That is why, President, because of those 3 days to come, and my desire, like the reservists in the Israeli army, to support a government of democracy, not to rush this bill before Monday. At least let us hear where the judges are going, their interpretation of Section 96(1). So, in a country where cohesiveness is important in the social fabric, in a country where, on a matter relating to the Constitution, democracy is better served if consensus can be found. You recall, President, that the debate leading up to the Charter of Rights in 2011 being passed was on the basis of working through consensus. Democracy is better served when efforts are made to achieve consensus. We will not always achieve consensus, but the efforts to achieve consensus provide us with better outcome. And President, you will recall that when this Senate debated the issue of acceding to the CCJ, we worked across the aisles, behind the aisles, inside back rooms to achieve that consensus. Senator Morris, you were president, and you would recall some of the discussions and some of the players on that constitutional issue of acceding to the CCJ and leaving the Privy Council. So again I say, when we're going to change the Constitution in the way we wish to do it, don't rush such a bill. Don't rush such a bill. Allow for the dialogue. Allow for the stakeholders in the society to have their say. And then we in Parliament take our decision. And President, let me just pause to acknowledge, as it has been done, the former Speaker of the House, former Senator, and my trade union friend. He has been in the trenches with me, and I have been with him, and I'm sure that he supports the ILO Convention 135 on the rights of workers, representative to talk out on behalf of workers. I salute you, Colonel Pacho Charles.
Thank you very much. And Senator Brown, I should have acknowledged him earlier, but you realize that he has
I know, you're in and out.
Yes, so we welcome former Speaker, former Member of Parliament, former Minister, former Deputy
Senator,
Leader of the
former
Jamaica
Senator.
Labour Party. I did say that.
Yes.
Welcome.
Fly at the church to it. So, President, my plea in this debate is that this is too important a matter for us to ram through on the basis of a majority. Because some people will describe it, Senator Braham, as the tyranny of the majority. Because the issue is not whether the words of the Constitution says you can do it by a majority. The issue is the spirit of the Constitution. The spirit of the Constitution. You can say nonsense, I know, because that's what you delve in. But that's fine with me. The spirit of the Constitution, the process by which we do this. And yes, the Gleaner editorial is correct. It is the process. Certainly not you, because you are 150 for the dollar, and we pass the 150 mark. Right, Damien? Yes, so him not even write it. Mr. President, in respect to this bill, it is my intention to propose 2 amendments when we come to committee. Firstly, that the effective date of this bill be the 1st of January 2024. That the effective date of this bill be 1st of January 2024. First amendment I wish to propose to this bill. The second one, President, is that this bill should not apply to the current incumbents, because the incumbents are already sitting on contracts. And we shouldn't pass amendment to the Constitution for individuals. We should do it for the principle. For the principle. And to do it as the government intends to do it. For the government to do it in the way they intend is to give the appearance that it's about personality rather than principle. Let me repeat it. The way the government is approaching this, especially to rush it before Monday's judgment of the full court, is to give sway to personalities over constitutional principles, which is why in committee, I will make the amendments that I am proposing. President, I am not afraid to say I disagree with learned King's Counsel Brian on the Constitution and the spirit of the Constitution being applied. Because in this Senate, I was present when others argue on the government side that the NIDS bill was constitutional. I was present. I was present. And even when we amended it, the courts ruled that it was unconstitutional. I have been in this Senate when my friend the President lambasted us for opposing the state of emergency, a state of emergency which allowed for the locking up of Everton, Morgan, and others, for which the court have said those arrests were in violation of the Constitution. I have been here, President, when King's Counsel and the government benches have said a single judge cannot decide on constitutional matters. Yet the Court of Appeals, quoting the Privy Council, has said in appropriate circumstances, a single judge, as in the Everton Morgan et al. Case, can so rule. Everton and Douglas, sorry, I don't know why I call him Everton Morgan. Everton Douglas. So, President, we on this side is not moved by the declaration that the words of the Constitution may be met. That's certainly subject to interpretation. That's why we have co-equal branches. And that's why Senator Sinclair, again, I would have preferred this debate to take place after the full court rule on Monday. I'd have preferred, I would prefer we wait until the full court rule on Monday. But you can get up on a point of order if you want, because I will repeat that comes Monday, there's going to be a judgment. I don't know the judgment, but I read. On the 14th of July, the Gleaner said, Paula's D-Day, that the judges reserve judgment until the 31st of July. That's in public. That doesn't influence the outcome of the decision. But the country must know that this indecent is taking place before that judgment sees the light of day. That's why I oppose the motion to suspend the standing order. That is why I'm opposing this bill. This bill, if it applies to future DPP, and it has nothing to, let me make it clear, it has nothing to do with my view about the incumbent. Incumbent is somebody I get along with well. I have a lot of respect for her. I may sometimes agree with her decisions. I may sometimes disagree. And yes, she seeks to explain her decisions. So this has nothing to do with Paula Llewellyn. It has to do with the principle of constitutional amendments, that such amendment must be for a proper purpose, not to facilitate a single individual. Because when we get to that level, we can then do all the amendments we want without respect for the rule of law. Mr. President, I have seen in Israel Netanyahu decide to reduce the power of the Supreme Court. They have a different political system than us. But the mindset of the executive standing not co-equal, but above the judiciary, offends me and it offends my oath to uphold the Constitution of Jamaica. No. Oh, Colonel. Is he finished, Mr. President? Is young Apka Fitzhenley finished speaking so I can continue? Because what he says makes no sense. But he's allowed to live in the land of nonsense. Mr. President, the people of Jamaica must have a say in this bill. We can't just rush it through in a single week. When the agenda for the Senate first came out, it was not this week. It was not on the agenda. It is an addendum to the agenda in a second message. The same thing applied in the House. And Mr. President, when I read today in the Gleaner that Minister Delroy Chuck said that some of the things he said in the other House was incorrect about the Ministry of Finance driving the speed of this bill, I asked the government, why not learn from that and not rush this bill? Pause. See if Minister Chuck made an error, misled the other place. And I'm happy that Senator Samuda didn't just cut and paste those errors in Minister Chuck's speech. But those errors are fundamental. It says the Ministry of Finance and the Ministry of Justice seems to be in malice. One says not me, the other one says you. And President, what they have resorted to in bringing this bill is what I call the shaggy defense. Caught me on the sofa, it wasn't me. Caught me on camera, it wasn't me. So why should it be we? Why should it be we approving by a majority this rushed bill? This bill is not even clear as to whether it should have retrospective effect. And therefore, we must assume it is not retrospective. This bill needs reworking. This bill needs reworking. It shouldn't be rushed, Senator Webby, through the Senate today. I'm opposed to it. Mr. President, this idea about synchronizing retirement age, it's a debate that we need to have. I have moved a motion in the past in the Senate about having a national retirement age. You yourself, President, have spoken about judges and retirement age for judges. Mr. President, and I'm going to raise this picture. What is the retirement age for security forces?
48 for a major.
48 for a major. 55 for chief of staff, which is why some thin-skinned persons attacking Ron James. No, it may not be in the Constitution, but I'm talking about if you're synchronizing national retirement ages. Look at that too. And so I ask again, why the need to rush this bill before Monday's judgment? Why? Why? It reminds me, President, of declaring a state of emergency and the same day that the court reject as unconstitutional aspects of the state of emergency. It reminds me of the Bail Act, for which KD Knight was suspended from the Senate because he stood up and asked for more time. We on this side, President, you will recall. Oh, you mean I should say he was suspended during the debate? Tell me what he was suspended for then. I remember, but you tell me, since you want to interrupt me.
I want to interrupt you because you say a member of the... Listen to what you said. KD Knight was suspended from the Senate because he stood up and asked for more time. That is not true.
Why was he suspended?
You find out.
That's what I'm trying to do through you. That's what I'm trying to do through you. Because I'm not going to say...
Since you don't know, don't talk what you
President,
don't know.
You don't know what I don't know. And you don't know what I know. But you and I know that you know and I know. Good. And you and I know that you did not defend KD Knight when he was suspended. So, President, let us be absolutely clear. This bill is not needed now. This bill should apply to the future, not to the incumbent. This bill should not take effect immediately. This bill should take effect on the 1st of January 2024. I do not support this bill, and I hope that my name will be recorded in Hansard as opposed to the bill and the process that has brought it before us. With that, Mr. President, and being approximate to 1:20, may I take my seat and wish you well and hope that you will tell us why KD Knight was suspended. You may not know why Ron James was, but it's a disgrace what they've done to Ron James. May it please you.
Who you call Ron James, by the way? No, I just wanted to know. Thank you, Senator Brown, and I assure you that your vote will be... You don't drink, man, so don't draw me into that. Thank you, Senator Brown. Thank you, Senator Brown. Senator Don Webby.
Yes. Is it working?
Hansard, you need to tell me if you can hear that mic, please. Hansard? You need to tell me if you can hear that mic. You hear?
I think, Mr. President, are you hearing me okay? Are you hearing me okay? Okay, thank you very much. Thank you very much. Mr. President, I'll be very brief like my colleague Senator Fraser Binns in this presentation. No, when I say it, I mean it. Mr. President, I rise to contribute to the debate on the Constitution amendment of sections 96(1) and 121(1) Act 2023. Mr. President, I understand very clearly the emotions. The amendment being proposed today affects two very, very important public offices within our country, the Director of Public Prosecutions and the Auditor General. Let me say from a personal point of view, I believe the ladies who hold these offices, Ms. Paula Llewellyn and Pamela Monroe Ellis, a fellow accountant, have served their country well and are two outstanding Jamaican women. They have stayed true to the mandate of their offices and upheld the highest standards of work expected of them. Mr. President, I'm sorry that he's not here, but my fellow colleague, Senator Ransford Brigham, I will say that I thought his brief presentation was simply outstanding. He spoke to the facts. And if I heard him correctly, which I think I did, he was saying that there is no breach of the Constitution based on his interpretation. Mr. President, Mr. President, I believe the opposition taking it to court really against the spirit of the Constitution is their right. I believe it's your right. I believe it's your right. And Senator Brown, like you.
Yeah, you did, but I was too busy concentrating on something that you had said to listen. I was too busy concentrating on something that you had said to listen to the sense that you were making.
Mr. President, the time being 1:20 p.m., in spite of what others across the way might think, I ask that the Senate be allowed to sit beyond 1:30 p.m. to complete the business of the day.
Thank you. Members would have heard the question. Those in favor?
Sorry, thank you very much.
Members would have heard the question. Those in favor?
Thank you very much. Thank you very much, Senator Hill and colleagues. As I was saying, Mr. President and colleagues, I think the opposition is doing their job by taking it to the court. And Senator Brown, I, like you, anxiously await the outcome of the ruling of the court. Mr. President,
point of order. Oh, sorry, it's not Sinclair up the chair. Sorry, I withdraw.
Mr. President, I have been reading, as I'm sure all of you have been, in terms of what is being said in the press. And one of the country's leading attorney, Peter Champagne, made a point which really resonated with me, where he says that this extension brings Jamaica in line with other countries in the region, which I think is an important point to be made. In listening carefully to the contributions, Mr. President, and in looking at what is being proposed in terms of these amendments, our focus, Mr. President, our focus must remain on the office itself and not the office holder. We have to look in terms of the office. Mr. President, there was an editorial, I think it was on Wednesday, July 26th, in one of the leading newspapers, and the headline read, "What does Mark Golding have against the DPP, Paula Llewellyn?" And I thought that editorial was quite good. It referred to her 45 years of prosecutorial experience. It referred to 33 years spent in the office of the DPP. And it refers to her stewardship from 2008 and her outstanding work as a director of public prosecution. Mr. President, I must highlight, and I feel very proud of Paula, being the first Jamaican woman to hold that office. As a professional woman, I think the greatest respect and admiration must be paid to Paula Llewellyn. And Mr. President, to be honest, it makes me sad. It makes me sad because this debate and what I'm reading has become very personalized for somebody that has given so much service to her country. I think it's very sad. And when you hear the innuendos about favors, you're basically questioning the lady's integrity, and that makes me sad. Mr. President, I heard Senator Brown, and Senator Brown, you can correct me if I'm wrong, but in 2017, with the passage of the Pensions Public Service Act, it is, and I'd have to refer to the legal eagles, but it is my opinion that this step is really to concretize what we are all aware of from 2017. So it's not really a surprise to me. And if I recall correctly, in 2017, I didn't hear any objection of that extension. 2017 with the Public Service Act. So Mr. President, with the change in retirement age for public sector workers, how could the government, in good conscience, not also extend the retirement age for these two offices based on the 2017 Pension Publics Act? It seems, Mr. President, Mr. President, as a fair and equitable in these circumstances. Mr. President, and I'm sure I've never seen Senator Bunting. I've seen a different side of you this morning. Yeah, really, really. And I'm very surprised. But yes, Senator Motley. I see you have it in your. I see you have it up. Anyway, I'm surprised. I've known him for close to 30 years, and I've never seen that side of Senator. I've heard about it, but I've never seen that side about him before. Mr. President, there's an issue that I raised with Senator Bunting because I know that he's going to be fully aligned with me as a private sector person. And one of the things, and I'm not very familiar with it in the public sector, Senator Bunting, but this whole issue of proper succession planning at the agency level and at all levels. I'm not speaking about this office. I'm not sure how robust we are in terms of development and executive development in these agencies. And it's something, Mr. President, that I think we need to look at very, very carefully going forward. So in closing, Mr. President, I want to state without hesitation that I offer my full support for the amendments. I thank you, Mr. President. May it please you.
Thank you very much.
Okay.
Senator Webby.
Thank you very much, Mr. President.
Senator Morris.
No. Sorry. I rise to make my brief contribution to this debate on the amendment to the Constitution, particular Section 96 and 121. And in doing so, Mr. President, I want to refute categorically an argument that I've heard and repeated by Senator Webby just now in this Senate, this debate, about an attack of the opposition on the current director of public prosecution, which is totally false and erroneous. Totally false and erroneous. Because, Mr. President, the mere fact that the government, based on its Nicodemus approach to constitutional reform, has brought the whole landscape, the whole environment surrounding the Office of the Director of Public Prosecution into disrepute. And in that process, spotlight has been placed on the current office holder. But no one on this side has ever questioned her character. No one on this side has ever questioned her integrity. No one on this side has ever questioned her years of public service.
Just as a matter of interest, that applies to Monroe.
Mr. President,
I can ask you a question.
No, Mr. President.
I can ask you a question.
You are not supposed to be participating in the debate.
I'm not participating, I'm asking you a question. I'm asking you a question, you know.
Yeah, yes, Mr. President.
As a president to a president.
No, I'm just a lowly member of the Senate.
I'm just inquiring whether everything you say applies to Ms. Monroe Ellis as well.
I wasn't speaking about Mrs. Monroe Ellis. Mr. President, if you notice, if Mr. President,
I just wondered if that was the case.
Mr. President, and that is why the practice has generally been that the president, who is the umpire in the debate, listens. Listen to me, you see your problem is that you have moved from becoming a journalist to one of the most tribal individuals in the parliament. And all right. Anyway, all right. Anyway, Mr. President, in this debate, if you notice,
No, I'm going to ask everybody, including myself, to allow Senator Morris to complete his presentation without interruption.
Mr. President, you notice in my prefacing comments what I've said is that Senator Webby in particular, I was responding to a comment made by Senator Webby and something that I've heard bantered about in the public space. And I'm responding to that and not in particular to Mrs. Monroe Ellis, right? So I'm speaking about that particular situation. But, Mr. President, my substantial presentation has to do with the fact that historically, democracies have been about people vesting power in governments that they trust and vesting those powers in the government to make just decision on their behalf. And in the process, they expect consultations to take place on some foundational issues relating to government. I mean, you have some states like in Switzerland where every major issue the government consults the citizens in various formats that they have established. In our situation, it's not like that on a day-to-day basis. But we have established a constitution which we regard as the supreme law of the land. The supreme law of the land. And it is expected, based on how democracies are treated across the world, how we have operated since gaining independence in 1962, that there are discussions that take place. And as I said, even if there is not an agreement, there is a public discourse on some of these issues as it relates to our Constitution. And we are expecting a similar situation for this. As Senator Motley has pointed out, that in the committee that they have established to deal with constitutional reform, nothing relating to this matter came to the fore. And she, as a part of our team from the opposition, would have been prepared to facilitate a discussion on the matter and how to treat it. So, it is shocking to us on this side that overnight, this matter has been brought to the Parliament to be debated and passed the same day. That's not how you treat a fundamental institution of our democracy. That is not how you treat a constitution that is supposed to be supreme where your laws are concerned. That is not how you treat it. I'm not telling you that this thing here violates the Constitution. You know, me I'm not judge.
That's right.
I am not a judge. I leave that to the courts to decide. But I am saying that there are some principles by which we operate in our democracy. There are some principles by which we operate in our parliamentary system. And consultation is quintessential in terms of our democracy, our parliamentary democracy. And you are trampling upon that process. Trampling upon that process. And if you should do a case study of how you have operated in government, you would realize that a significant portion of the constitutional cases that you have brought, that have been brought against you, you have lost them in the court. Because this government is operating in an arrogant and hubris way. Arrogant and hubris way. And let me tell you something, Mr. President.
Because he's taking on Senator Bunting, who is taking on Senator Samuda, who is both interrupting Senator Morris.
And Mr. President.
And Senator Brown is playing the role of the backbench president. Go ahead, please, Senator Morris.
And Mr. President, in the process, you are supposed to be the presiding officer and umpire. Is not presenting me, protecting me, who's on my feet and
I never know of you.
In the debate.
I
because
never know
you are
of you.
Distracted, Mr. President.
I never know of you needing my protection. But if you think I'm distracting you, go ahead.
All the time, Mr. President. And I must say, Mr. President, I really forget not to acknowledge my friend, my church brother, former Minister Pernell Charles. It's my very good friend. And
I heard that he was in the parish helping you with your endeavor the other day, but it never quite worked out.
Leave that alone, Mr. President. Mr. President, I must say, that consultation is very important to the constitutional reform process. And no matter what the bantering that have taken place, the mere fact that the government set up that constitutional reform committee And that committee has a wide cross-section of individuals, and individuals are going around and speaking to people across the country, soliciting their views as to what the Constitution should look like, or the amendment to the Constitution should look like. Commendable. But what is taking place here today is a mockery of that process. It is a mockery of that process. Because there is nothing, unless the government knows something that I don't know, that gives this sort of speed and urgency to the overnight amendment to the Constitution. Nothing. Nothing that can make it wait on the Constitution Reform Committee to do its work and make a deliberative and informed position as to how best to treat it. And you see, you as government is kicking over your own milk, and you by your action is riling up the people against you. And that is why when I went to the gas station the other day, Senator Brown, and I saw my friend who is insane, and I generally give him my support for his medication. And after him get him thing and him a go leave, him said to me, say, boss, me tired of them. Me tired of them. And then when I left there, I went up Stony Hill, and I stopped at a certain restaurant. And the people there said to me, say, boss, you hurry up and do what you do, because I'm tired of them. And when I went round to the junction and stopped by the soup vendor, the soup vendor, them said to me, say, boss, me tired of them. And me go round a Rosen at a certain spot where Damien is very much familiar with them sell jerk chicken. And them say, and the people them say, me tired of them. And when we go down to Port Maria, the people say, boss, we tired of them. We tired of them. And you must all take note of that. The people are watching your conduct. The people are watching your behavior. The people are watching your operation, and they are tired of you, and they will act accordingly in due time. May it please you, Mr. President. You got tired to hear that speech?
Well, we all came to hear Senator Golden this morning, so we are here in the afternoon.
And Mr. President,
And I'm not going to allow you to weave your State of the Nation presentation into this.
no, Mr. President, I'm going to leave my State of the Nation presentation for the time when it is due, because I have just as many substantive things to say in that presentation as I'm about to say now. Mr. President, I must admit that I have been a little bit entertained today by the great amount of emotion that has come from the opposition benches. A lot of hyperbole, a lot of hype, a lot of what I'm going to demonstrate to you are baseless criticisms. So I heard, Mr. President, that the opposition was or is quite upset about the lack of consultation with the opposition leader. So I tried to identify what was at the heart of the opposition members' concerns, and that was the first thing, no consultation. I also heard great consternation over the rushing through of this bill in the Senate today. And beyond those two issues, which I am quite prepared to deal with, what I really heard was a personalization of the entire issue around the individual as opposed to the office. This is not a bill about Paula Llewellyn. This is not a bill about, well, if you listen, Senator Bunting, I will school you. Listen, I will tell you shortly. This is not a bill about Pamela Monroe Ellis either. It is a bill, you had your moment, you know, let me have mine. Unless you have a point of order, let me have mine. I'm not yielding it. I'm not yielding it. The bill before us is a constitutional amendment to sections 96(1) and 121 of 121 subsection 1 of the Constitution. And I am compelled, Mr. President, to read those sections, and I crave your indulgence in doing so for the very reason that I suspect the members on the opposition benches have not thoroughly read it. So if you will permit me, section 96(1) says, subject to the provisions of subsections 4 to 7 inclusive of this section, I'm going to shorten it up, the DPP shall hold office until he attains the age of 60 years, provided that A, he may at any time resign his office, and B, the Governor General, acting on the recommendation of the Prime Minister after consultation with the Leader of Opposition, may permit a DPP who has attained the age of 60 to continue in office until he has attained such later age, not exceeding 65 years, as may, before the DPP has attained the age of 60 years, have been agreed between them. So if there is to be an extension on the DPP's time in office beyond 60 years, the Leader of Opposition must be consulted with, and the Governor General, acting on the recommendation of the Prime Minister after that consultation, can act to extend the time between 60 and 65 years. I'm going to hold on the Auditor General provision because I don't really think the focus of the opposition contribution was really the section of the Auditor General, although I will note for you that section 121(1) has similar language, albeit it refers to the Auditor General. So, Mr. President, I remember before I ever studied law, back in the time when there was a discussion about the Privy Council and the CCJ, in the late 90s, early 2000s, I used to hear them on the radio. When I was living abroad, I would listen to the Jamaican radio in my lunch break. And I would hear them talking about entrenched and deeply entrenched. And I had absolutely no clue what it meant. And I suspect the vast majority of Jamaican people are still confused about it. So let's talk about that. 3 types of provisions: ordinary, entrenched, deeply entrenched. The ordinary one says that you come into the House of Parliament and a majority vote carries that bill or that amendment on the Constitution. We're talking about the Jamaican Constitution. The entrenched one says, and I have to read it because it's a little complicated and sometimes I don't want to misspeak, that with the entrenched provision, you can't submit the bill. Once you have voted, you can't submit the bill to the Governor General for his assent unless you allow 3 months to pass after the introduction in the House of Representatives and the start of the debate. And then you have another 3 months pass after the conclusion of the debate. So 3 months have to elapse before you start the debate after tabling, 3 months when the debate is finished. And then the deeply entrenched one has even more stages that you have to allow the bill to rest before it can become law. The relevant one here is the ordinary. And why is it relevant, Mr. President? It is relevant because of the provisions of the Constitution which are captured as entrenched provisions or deeply entrenched provisions. Section 96(1) and Section 121(1) are not any of them. So what that means is that in the profound wisdom of the fathers of this Constitution of our country, they crafted a Constitution in which 96(1) and 121(1) can be amended by a simple majority vote by an ordinary act of Parliament, and that is set out in Section 49(1), which says, let me read it again, subject to the provisions of this section, Parliament may, by Act of Parliament, passed by both houses, alter any of the provisions of this Constitution, or insofar as it forms part of the law of Jamaica, any of the provisions of the Jamaica Independence Act. It means a regular bill must be tabled, passed in the House of Representatives by simple majority, more than 50% of the vote, and a regular bill, just like all the others we have tabled here today, must be tabled in the Senate and passed by a simple majority. Mr. President, that's the bill before us today. Further to that, hold on, I'm not finished yet, Senator Sinclair. Further to that, Mr. President, while Section 96(1), Section 96(1) requires the Prime Minister to consult with the Leader of Opposition to agree, well, it's not to agree, he's just required to consult with him in relation to the extension of the years in which the DPP or Auditor General under 121(1) can serve, up to 65. So if he's extending, he must consult with the Leader of Opposition, and then and only then, after that consultation, can the Governor General appoint or extend the appointment of the office. Of the office, not the person, of the office. But, Mr. President, here is where the rubber hits the road. Section 96(1) and 121(1) are governed by Section 49. And Section 49 requires no consultation whatsoever. It is an ordinary bill that must come. It must be laid. It must go to a vote. And when it passes, it passes. So the second point, hold on, let me go back a little bit. I want the people who are listening to hear this, because there's been so much drama this morning that, if you don't mind, people get confused with the hyperbole and the hype and the fake news and the baseless criticisms. So let me go back a little bit. There is no requirement under the Constitution of Jamaica for the Prime Minister to consult with the Leader of Opposition in order to amend Section 96(1) or Section 121(1). No requirement. The Constitution says lay a bill, pass the bill, and move on. Listen up. Listen up. You get a chance to vote. You see what you're confusing, Senator Brown, is the ability to vote with the ability to govern. You lost that. Mr. President, the second part of the concerns that I heard was this question about rushing the bill through the Senate. And what was the word used? Abuse. Abuse. Yes. All of those are emotive, you know. Let me tell you, it's a whole heap of emotion was going on that side of the Senate this morning. So let's deal with that. Because I don't deal with emotions, you know. I deal with the rule book. I deal with the law. I deal with the Constitution, and I deal with the standing orders. Section 83, which I believe you tried to school him in, the Deputy President tried to school, is the provision in the Senate standing orders that deals with the suspension of standing orders. It is a lawful act that can be done in the Senate. It says, let me put on the glasses so I can read it so I don't miss out any words, so Senator Brown can hear me loud and clear. And you notice I'm talking louder today? I'm lifting my voice just so I don't make any mistake and there's nothing that you don't hear. Any one or more of these standing orders, but you can't hear if you're talking while I'm talking though, you know. I pause because I don't want you to miss anything. Anyone? You know you just said that 2 minutes ago, right? Oh, it's repeating. Not forget, you forget. Okay, all right, okay.
What did he learn? What did he learn in the 70s from Trevor?
I was wondering. Any one or more of these standing orders may, after notice or with the leave of the President, be suspended on a motion made by a member at any sitting. It means a motion to suspend the standing orders in order to take a bill through expedited stages as opposed to the stages in other standing orders is a permissible thing to do on the accession of a majority vote in Senate. What do I mean? I don't want to use no big words. I don't want the people them to understand me. Make us say it again. You can bring a motion and say you want to suspend the standing orders and all of we vote, and if more of us vote, that is the vote that's going to carry. It's an appropriate, lawful use of the standing orders. It is no abuse. Certainly. So, Mr. President, having scoured the arguments, having listened very carefully, to the members on the other side, I can find no substantive, credible reason for their great consternation that has sent them into such an elevated emotional state of mind. I can't find any. But what I have heard that has disturbed me, and I don't really want to go too far into it, because I do not wish to contribute to the breaking down, the attack on a credible, necessary, and extremely important institution of our country, that of the office of the DPP and the Auditor General. I think it is of concern that so much motive has been imputed as to why this is to be done, and the motive that is being imputed suggests to me that there is some attempt to create and obfuscate and build up some sort of stories to distract people from the law as I have set it out. The law provides for this amendment. The Constitution provides for this amendment. Senator Braham was correct. If the Constitution so provides, on what basis do you say that this is immoral? On what basis? And so the only basis that I can surmise, and I am not a girl that likes to throw what I think may be behind things, but I do know, Mr. President, that there has been extremely serious breaches of our laws at the high levels of political office on that side. And I wonder, Mr. President, if there is an attempt to sideline that matter, to move quickly past it, and instead to focus on something that is not in fact a breach of the Constitution, that is not in fact a breach of the law, that is not improper, that is permissible. The bill before us, ordinary legislation to be passed by a majority of both houses of Parliament. May it please you, Mr. President, there is nothing offensive in this bill.
Thank you, Senator Sherene. Thank you, Senator Sherene Golden Campbell.
My knowledge, Mr. President? Oh,
Mr. Crawford.
Thank you very much, Mr. President. Well, I have no need to shout because I am at no heightened emotional state. I have analyzed the conversations over the last few days, the presentations in the lower house, and indeed the presentations in the upper house. But before I start my presentation, Mr. President, I'd like also to acknowledge former Speaker of the House. What is the correct term for a former Speaker of the House? Furniture. Thank you very much. Who is a person that I myself can say have been very kind to me personally. And I remember one conversation he was trying to advise me. He said, your duty is not to change everything you want to change, but to move it closer and don't die in your attempt. I'll never forget that conversation when an article about no handout came in the newspaper. Sir, I thank you, and I acknowledge as well your daughter, sir, and Member of Parliament, Ms. Charles, for her presence, and whatever respect and gratitude I have to you, pass to all your children. So by extension, it is passed on. To our former colleague, Senator Campbell Rodriguez. Yes, I know I am so happy because I used to look and see your agreement over there. Now I have to focus this way to see your agreement in this case. But I am very happy to see you here today. Mr. President, I ask for your protection from Mr. President. Whenever there is a debate in the Senate, and I put it to you even in the lower house, there are many hurdles to cross before one reaches to agreement. One initial hurdle is if the proposal abides by the Constitution. But that is not the only hurdle. My good friend, Senator Floyd Morris, stated that he is not prepared to be the judge on that matter. But it's clear that there's a difference in opinion on whether it crosses the first hurdle of being constitutionally correct. But if it was that we stopped only at the constitutionality of the bills before us, then many would not need a debate. Because the majority of bills that we debate and accept, reject, or quarrel about is not perceived by any side to be in contravention of the Constitution. So therefore, if there is indeed, and there clearly is by legal trained and legal luminaries, on this side, Senator Donna Scott Motley has said she believes there may be. On that side, Senator Ransford Braham has said he believes there may not be. And there is an appropriate space for that conversation and that deliberation. And Senator Scott Motley said the courts, and correctly, Senator Don Webby said it is her right and our right and the nation's right to seek an answer if there's a difference in opinion. However, the debate don't stop there. The debate actually starts there because there are multiple other hurdles, as is what is being done, why it's being done, and how it's being done. Therefore, my first point of departure with Senator Golden Campbell is the treatment of the Constitution and the things within the Constitution. Every letter, every word, every sentence, every comma is important. And because of the importance of the Constitution, is even more important than some of the other bills that we have looked at in here. Indeed, while I served in the lower house, it is in this house that I knew the vast importance of a simple comma, or a term shall or may. Have we not had extensive debates and indeed recommended changes to a single word in bills less important than the Constitution? So therefore, any change, if it's even a comma, deserves a treatment that recommends to the nation and its citizens that the Constitution is very, very, very important. What therefore is the reason for, is it chagrin, for consternation, for concern, is, it seems to me, the treatment of the Constitution in this particular change belies the importance that the Constitution should have and creates precedent that any Jamaican should be concerned about. Indeed, Senator Bunting, if an act happens on its own, it may receive less weight than it is a part of a trend. Most mathematicians and scientists will say that a number by itself has less answers than a number as a part of a trend. We have seen in this country, in recent times, as perceived and created by this government, multiplicity of acts that could be perceived and that has been found to be treating the Constitution that as less important than it should be treated. The grave concern of this particular one, therefore, is because it is a continuance of what we had recognized even more recently as the act of implementing new states of emergency to avoid coming to the Parliament for its extension. That could not have been the intent, or as Senator Webby said, the spirit of the Constitution, that to avoid the Parliament, you do a new one every 14 days, as versus come for an extension and risk a debate. We have seen where the Justice Sykes would have been asked or considered to have, what was it, a probation period as Chief Justice. We have seen where senators were asked to sign letters committing them to agreement. Well, undated only means the length of their commitment into infinity. But they could have signed one for just this debate. And then this debate moves on. In fact, if I should go back to the state of emergency in this house, I think it was the leader said, thank the Lord we will not consider that recommendation. And then did it. No, I can't call Uncle Randy Dave. I'm biased in this. I'm biased. And knowing him, he still believes it to be true. So this particular one, on the what, and the why, and the how, is creating concern, because I'm not saying if it can be done. I'm not an authority in the law. What I'm debating is if it should be done. And if it should be done in this way. What are some of the considerations that we have before us? One of which is that the Constitution is the supreme law. And indeed, if there is a discrepancy between another law and the Constitution, it is the another law that is supposed to be corrected. What we have is a recommendation that the discrepancy's direction of correction is to correct the Constitution. Now, this might be in the case. No, you have to give me a chance. Yes, because other than that, we won't leave here. Huh? And he's my neighbor, you know. But what I'm saying is that the precedent of saying, of thinking, of acting in a way that the Minister of Justice says the correction of the Constitution is based on its contravention of the Pensions Act. Let us look then. And I quote, the proposed amendment, if amendment is change, correction, to the Constitution will allow for the expansion of the term of service for 60 years, from 60 years to 65 years, thereby addressing the inconsistencies that currently exist between the two pieces of legislation, and by extension creating a more equitable playing field for all, unquote. So, well, I'm saying that by practice, that by precedent, that by rule, we should be careful of the direction of correction, and people therefore are concerned. I also must suggest to you that and I've been watching some cases now on YouTube, so I'm a YouTube lawyer now. And yeah, I'm a lawyer, village lawyer. But I've seen where they're saying some cases don't have the gun, don't have the nothing, but it is built by just different things coming together. What the circumstantial evidence. And then the judge, you watch a case them to me, yeah? Oh, Tommy's teaching a law. And the jury should put all those circumstantial evidence together and use logic to make a determination. Indeed, I have no axe to grind. I think I've met the DPP once. But circumstantial evidence suggests that there seems to be a correlation with the date of the end of the current DPP's contract and the act and rush to ensure that the last day of Parliament before that date treats with a matter that for some reason couldn't wait on all the other changes that is coming, that for some reason couldn't wait on Parliament coming back in, but also that with the date of the end of the DPP's contract being September 2023, there has been no internal nor external effort to find a new DPP. So therefore, if the government had intended that the September 2023 meant something for the office of the DPP, then the government would have mistreated that intention, having not made no attempt, no advertisement, no interview, no nothing. And to my knowledge, no succession planning, as Senator Dunwebby said. And to my knowledge, you can't have an acting DPP. Senator Scott Matley, am I correct that you can't have an acting DPP? You can't have an acting DPP. So maybe the government was intending to go through a process of acting DPP. Yes, that never company. The algorithms never carry that one. But maybe the government had intended, in spite of the fact that the government gave an extension 3 years ago to end in September, and knew that that extension would have been up. Not only did they give 3, they give 3 even though available to them was 5. They said 3. And the GG. And not only was 3 agreed to, a basis was presented by the government. That basis was 2 very important cases, one of which was the Klansman case, and the other one, Wilson. Both have been completed. And not only completed, none was led by the current DPP. In fact, they are being led by people who are still there and who don't know in year 63. And that's an important point. Because if it is that we're going to change the Constitution, it must be that we find that the needs of the society or the interest of justice is about to be served. That desperate actions are for desperate measures for desperate situations. What is the desperation? What is the desperation that we have observed that there can be no delay in the correction of something such as the age of retirement, when the only real emergency is the age of the current holder of the office of the DPP? What therefore? No one else has predicted to me what is the emergency. What's the emergency why October is too late, even though this reality existed for 3 years? The Pension Act has been established for 3 years, which means that the discrepancy has been there for 36 months. 6 years? The change was 2017? So the discrepancy existed for 6 years? For 72 months? 72? Yes. I was going to give them the number of days, but it was risky. It was risky. Yes, yes, I have some calculator over there. What has caused for we to be called back to Parliament? For all the quarrels to be ignored? For the consultation to be unnecessary? What's the emergency? And also, why would we put an office so important into not only disrepute, but to contravene what is one of the basic rules of justice, that it must not only be done, but it must be seen, perceived, believed to be done? We have had, we're not going to ask you. But in this house today, 2 members of that side have accused the government of being an enemy of the DPP. There was one article, why Mark Golden, what is his issue, or something like that. This is the person, the office, that will decide on who to carry to court, who not to carry to court. Now the public is left with the unfortunate probability, possibility, that they are going to analyze decisions of the office by who is an enemy and who is a friend. Instead of in a method as proposed by Senator Scott Martin.
Sorry, Senator, just 1 minute, please. 1 minute.
Yes, sir.
I'm sorry, members, I just wanted to acknowledge, and I'm doing this because I think she may leave, just wanted to acknowledge the presence of Mrs. Lorna Golden, wife of former Prime Minister Bruce Golden and aunt of our own Senator Sherene Golden Campbell. Welcome, Mrs. Golden. And I understand that you were also helping Senator Morris in St. Mary with his recent unsuccessful endeavor. But there's always another time, Senator Morris, so don't be disheartened. Sorry about that. Sorry about that, Senator.
Yes, no problem, sir. And I too would like to welcome and acknowledge also other members of the Golden family who clearly were here to support Senator Golden Campbell. And unfortunately, she wasn't able to do her presentation. Yes, so what is the emergency why they had to cancel Senator Golden Campbell's presentation? Nobody has. All right, cool. So, I said to you, therefore, that the office of the DPP, first of all, the Constitution is not an ordinary law. It's not an ordinary document. And no matter what is the level of the sentence or the section, should be treated lightly, none at all. But the office of the DPP is also not an ordinary office. And so therefore the treatment of that should also be handled in a particular way. This is not the first that we have been having this rush. I remember when there was the Road Traffic Act, and it was a straight rush. I remember my colleague, Senator, on many occasions had to ask that his disability be considered and time be given for him to review. This is not the first that these things are coming. And so therefore, what we're asking is that this not be that treatment. There's also, Mr. President, a suggestion that there was no consultation with the DPP and no consultation with the Attorney General about these extensions, the office of the DPP. So not only a breach, but they don't have any commitment that September means anything for extension. Because if there was no conversation or consultation, then maybe the current DPP is hell-bent on leaving in September. And it shows the health state of the, we call it the chaka-chaka management of the affairs of the country. A person will hold the office, and the office itself has not been consulted. But let us look on the office as though we can, but should we? I read earlier that more than 50% of the persons currently serving as prosecutors are less than 5 years of experience. Now, not only that's the case, but we must ask ourselves, what will be the impact of extending this period to where the probability of growth is so reduced that any real ambitious person may perceive that office not to be a long-term stop. And if those people perceive the office not to be a long-term stop, then what would be the level of turnover? And how will that affect our cases and the operations of the DPP? All of this is reasons for consultation. All of this is reasons for conversation, because there is an established thing about satisfaction with work effort. It is remuneration, salary, growth, and satisfaction with effort, and it's divided by prior effort, current effort, and risk. We know from just recently that their remuneration is not nothing that they're wonderful and satisfied about. Just recently, didn't that office senator had some action and some concerns? Yes. And that isn't being given priority. That isn't given priority. When the vast majority, don't they, 63. But that is not the priority. There was also some concern about how senior members have not been considered, have not been trained, have not been organized so that they can eventually take the position. Senior members, I think that I read earlier that there's 5 of high qualification. So there is no question that we have persons who are capable and able. And so that is why, if it is not a conversation about the person, then it don't have to be today. It can be October 2024. Because 7 years have passed, we can give 2 more. Whenever the house is reopened. So therefore, this effort that even the minister said no consultation was had. When lesser laws have been bragged about in this house, about the longevity of consultation. But for the Constitution, the minister himself said no consultation, not even with the areas that are of concern. So rushed it was that 2 ministers are now at quarrel as to who had it and who didn't have it. Who did it and who didn't did it. And none of those 2 is the person given the responsibility for constitutional change. So the two in quarrel is now being refereed by the one who should have been responsible. What's the reason for that haste? And what's the treatment for the Constitution? So, sir, if good governance is to be considered, it suggests that a precedent of flippant treatment of any section of the Constitution must be resisted and cannot be tolerated. It is that precedent that I am concerned about. And it is the trends that make that precedent seem to be likely to be continued that must be resisted, and that we on this side are resisting. So, belittling it to say consultation with the leader. Consultation with the leader as a citizen, because there should be consultation with the citizenry. For such an important office. And for any constitutional matter. So it's not just, oh, they never spoke to the opposition party. It is the treatment of something so important. That is why we need back civics in school. Civics for young Jamaicans. Because in the United States, where there is broad commitment to the Constitution, where the people say, my rights, this would never have been allowed. It will never been facilitated. So while that side may have to act in unison, I know there are many that feels that a document so important and a precedent so risky should not be allowed to move forward. Thank you, Mr. President.
Senator, one minute, Senator, 1 minute, Senator, 1 minute, Senator Fitzhenley. Thank you, Senator Crawford. May I have a brief word with Senators Bunting and Hill? Senator Hill?
Yeah, sure.
Members, in the interest of transparency, I just consulted the members concerning whether we wanted to continue a bit longer rather than taking a break, and it has been determined with the agreement of the clerk that we will press along and see how far we can get. Senator Apka Fitzhenley, you are recognized.
Thank you, sir. I've assumed my feet briefly, sir, to indicate my strong support for the bill which endeavors to increase the ages of retirement for two very important office holders in Jamaica, the Auditor General and the Director of Public Prosecutions. And the reason I'm supportive of the move is that I find it a sound basis that the Pensions Services Act, which was promulgated in 2017, sought to, among other things, gradually increase the age of retirement for public officers. And moves were not made in this regard for the Director of Public Prosecutions and the Auditor General. I think it is only fair and just that that be corrected. Indeed, it is this administration that moved to increase the retirement age for judges only a few years ago, and I note there was muted opposition to this. which begs the question that the constitutional officers, that is, well, the constitutional officer that is the DPP, is the argument that whoever that individual is not deserving of serving until age 65 with the opportunity of an extension and making submissions to people who have been afforded that facilitation. I think this move to bring some uniformity to the process is in good order. And indeed, it's a principle that is tried in the legal field, that equality before the law is to be encouraged. I want to make a point. I heard earlier the leader of opposition business read a letter to the Senate from a senior deputy director, where he alluded to a letter which he says was sent to office holders in Jamaica objecting to the extension in the tenure of the current director of public prosecutions. Another principle in law is that those who come to the bar should, and seek justice, should do so with equity. And perhaps if they are in custody, I was hoping, Mr. President, that this debate would be pursued in a manner that is not personalized. But unfortunately, based on the submissions of members of the opposition, we have seen aspersions cast on certain office holders, questions in the public domain whether promises were made about favors being granted. I think that is most unfortunate and unbecoming. That has been said in the public domain by no less a person than the leader of the opposition. That it raises the question of whether favors were promised in exchange for an extension. I find that unfortunate and unbecoming. Which brings me to my third point. It brings me to my third point. I want to advise the Jamaican people that though a perception might have been created that what is happening here is abnormal in terms of increasing the ages, the retirement ages of the Director of Public Prosecutions and the Auditor General, that is not so. In the majority of Caribbean countries, the retirement ages of the two office holders is 65 and some beyond. This is so in the United Kingdom, in Australia, and in Ireland. So this administration is acting lawfully and bringing what obtains in Jamaica into some form of, well, some semblance of uniformity with what happens or what is the current situation in other Caribbean countries. This side is acting lawfully in pursuing this amendment. And you know, Mr. President, before I close, I wish to make a couple of points and support a point articulated by the minister who tabled this bill. I heard the submissions by members of the opposition and I felt a bit saddened. And I'll tell you why. I heard politicians, some ages 62, some 66, some approaching their 70s, arguing against two outstanding Jamaicans who are in their early 60s, being given the opportunity to continue to give credible service to their country. And I think to myself, I ask the question, what gives us politicians the right to say to these office holders, whether DPP, AG, or judges, look here, we can serve as long as we like as legislators. But you see, you know, when you reach 60 enough of you, I don't like to use the word hypocrisy, Senator Webby. But when I heard the submissions of the members of the opposition, as I said, 62, 66, 69, I thought to myself that the posture may be interpreted as betraying a certain semblance of self-indulgence and double standards, a posture which I submit should not be countenanced when we make laws in the Parliament of Jamaica. Senator Brown, don't let me answer you. Because if I answer you, you walk out of here today. Don't let me answer you. It has also been suggested in the public domain that the government of Prime Minister Andrew Holness is in the habit of breaching the Constitution of Jamaica. And I wish to address that point centrally. It is true that as various administrations attempt to govern, that laws of the land, including the supreme law, in the view of some judges, might be contravened. It shouldn't happen, but it happens the world over. These things happen as administrations seek to govern with a conscience. And this has been the case from the former Michael Mann administration in the 1970s, when the Suppression of Crimes Act was struck down as unconstitutional, and when a panel of judges on the Supreme Court found immunity certificates issued by a former security minister as null, void, manifestly unreasonable, and not in conformity with the Constitution of Jamaica. These things happen, sir. And when the opposition, therefore, seeks to say...
Sorry, no, on a point of order, it hasn't been resolved yet. On a point of order, President.
1 minute.
The young member of the Senate.
What's the...
That's what I'm coming to. The young member of the Senate is discussing a matter that is before the courts, and for which a determination has not yet been finalized, and therefore that's not allowed under the standing order, and therefore it shouldn't be allowed to speak to it.
Continue, please.
The matter of the constitutionality of the immunity certificates is not before the court. Therefore,
I never asked you to respond to the alleged point of order, you know.
Well, here's what I can tell you, though, Mr. President. When the opposition, therefore, says this administration has a tendency of breaching the Constitution, that's not true. It's an argument that is false, a fallacy. It's unbecoming political propaganda. That's what that sort of rhetoric is. And as I close, I've heard members of the opposition speak about constitutional office holders and how they should conduct themselves. And again, I had hoped that we would be able to conclude this debate without personalizing the matter. But unfortunately, based on utterances by members of the opposition, in my view, in here and outside, the matter has been somewhat personalized. So I make this point. I heard a press conference, Mr. President, where a high constitutional office holder argued vociferously against the extension of the DPP's retirement age, and with muted effect, the Auditor General. And the suggestion was made that perhaps they are unfit for an extension, which would bring Jamaica in alignment with what obtains in other Caribbean countries. And I find, Mr. President, that there is significant irony in this. You don't start with noise yet. I find that there is significant irony in this posture by the opposition leader. And I'll tell you why. It is not the Director of Public Prosecutions or Auditor General, constitutional office holders, who I hear referring to Jamaicans as little boy and little girl. I haven't heard them do that. I've heard them conduct themselves with decency and decorum. It is surely not the DPP or AG who I've heard saying they want to run for office and surround themselves with Topanaris, suggesting that the ordinary Jamaican has no part to play in the leadership process. Again, I've heard the two office holders conduct themselves with decency and decorum. And you see, Senator Brown, I have never heard those two key constitutional office holders suggest that if unscrupulous behavior happens in the electoral process, it's no problem. I've never heard them tell Jamaicans, keep by your mouth, or refer to any of us as damn fools. So, I say this, Mr. President, it is not any of the two office holders with this pending extension in the retirement age who have conducted themselves in less than a desired manner. I think what the opposition should contemplate is whether a senior constitutional officer, the leader of the opposition who made the comments and postured in the manner I alluded to, is suited to occupy the key constitutional office which he currently occupies. That, I believe, is what the opposition should be contemplating, as opposed to casting aspersions on Jamaicans who have given yeoman service to their country. You see, Senator Bunting, you know, and anytime you will seek to interrupt me, you know, Senator Bunting, anytime you will seek to interrupt me, you know, I have said that Jamaicans are lucky that the Patterson era is over. You two are lucky because if Mr. Patterson was here, you wouldn't be near. He does not appoint losers. You wouldn't be near. So kindly govern your conduct while I make my presentation. Mr. President, I support this bill, which proposes to extend the tenure
President, and a point about
of the Auditor
why
General
is the former
and the DPP.
Prime Minister being brought into this cascade?
I conclude my presentation.
Why is the former Prime Minister being brought into this cascade?
Mr. President, am I recognized?
Thank you, Senator Fitzhenley. When she was here, you know, causality, she leave. Now she gone. You're saying that, yes, sir. Senator Bunting, Senator Fitzhenley.
Thank you. Thank you, Mr. President. I want to, first of all, acknowledge the courage of the author who, from the office of the DPP, who put a document to the Prime Minister and copied a number of ministers and constitutional office holders, parliamentary office holders. It really is a profile in courage. It really sheds some light on the true state.
Senator Bunting, hear what I'm going to say about that. I'm not stopping you, but I'm just going to say something, right? That letter was addressed to yourself, to myself, the Prime Minister, and the Leader of the Opposition,
and
right?
A couple more. And a few more persons.
Yeah. No, it was addressed to the Leader of Opposition Business in the Senate.
Yes.
It is clear that it is a document that could be characterized as a statement from a disgruntled. Let me
That's how you seek to characterize.
Yes.
That's how you seek to characterize.
So hold on now. It is already in the public domain, right? Now I'm not suggesting to you that you should not put it on the record of the Senate. I'm not suggesting that. But what I'm suggesting that perhaps you think about it before you do so. And if it is that you are putting the document in the public domain, I'm going to suggest to you that you put the entire document so that its context is clear, rather than taking snippets from it. And put the author name too, because she write it.
While you were out of the chamber, it was done, you know.
Oh.
It was done while you were out of the chamber. And a point of order,
but Mr. Bunting can deal with this issue.
No, clarification.
No, man. Mr. Bunting can deal with this issue.
And a point of clarification. No. I'm equal in this place too. The matter came up when the debate for suspending the standing orders arose. And those issues came up, including that the letter was addressed to you. And some parts of the letter was copied to you. Some part of the letter was read. So I can't see why we know.
So what I'm saying, just hang on. But with the greatest of respect, I do believe
that's what I'm saying. You might not have been known.
I do believe that Senator Bunting, who has quite a bit of experience in this as well as in the lower house, can handle himself in this matter.
No, it's not about him handling himself.
I don't think that somebody needs to rise, whether they get their legal.
No. I'm not a YouTube lawyer. I'm not a lawyer.
YouTube.
I'm a senator. I'm a senator with equal rights. I'm a senator with equal rights. And the point is, President, the government side, including yourself, trying to describe the right of a letter. One, a maxim. Now you're saying this maybe disgruntled. It's not becoming of us as senators.
Listen to what I'm saying.
Let's take it on face value.
Listen to what I'm saying.
On a point of clarification, Mr. President.
No, 1 minute. Listen to what I'm saying. Rather than taking the letter as some mystery, right? And pretending that it is some document. The document is written by a member of the DPP staff, one Kathy Pike. Right? So there it is, it's out in the open. There is nothing to hide. All I'm saying is this. What I'm telling you. If that be the case, read the document rather than taking out snippets. You're looking at a situation where there is a department of government, right? And one employee has written, and you are prepared to lift that document and give it status that it might not have. So let the people, hold on a little bit, man. Let the people decide. Put the document onto the record of the Senate. That's what you want to do. In other words, don't take the thing out of context. Yes,
you have
Mr.
a point of order?
Just a point of clarification, if I could be so allowed, President. This letter is the document or letter you're referring to is the one that is written by Deputy DPP Kathy Ann Pike. Is that the Senior Deputy DPP Kathy Ann Pike? By mentioning a name that was mentioned before and no such thing. And you can speak when it's your turn again. So on a point of clarification, President, is this the same person that resigned in Montserrat under a cloud of suspicion?
President.
Is this the same?
Point of order.
I need
This
to
is
be
an
clear.
abuse. This is abuse by Senator Samuda. No, don't go there. Don't go there. Don't go there. Don't go there.
Senator Brown, calm down.
Don't go
Calm
there.
down. But
It's
this
an
is
abuse, man.
this is exactly what I was trying to prevent, you know. This is what I was trying to prevent. So, Senator Bunting, you want to discuss the letter, and all I'm saying is, all I'm saying is my advice. All I'm saying, Senator Bunting, is that my advice is to put the letter into the record of the Senate if that's what you want.
And I will. And I'm happy to.
Bunting, it's addressed to the President. The
Yeah,
President
you,
can put things.
President, you have a copy of it. Just ask the clerk to circulate it. Clearly,
I'm not interested in putting it in the record of the Senate, you know. You are. So if you're going, so put it in. If you're going to, that's what you want to do.
Yes, and I'm happy to. There's a reason why it was sent at this time. But you know,
she's the same one convicted murderers.
I was hired by
Mr. President, there's a Jamaican proverb. There's a Jamaican proverb that says when fish come from river bottom and tell you say alligator have gum boil, believe them. Right? I'm sure you're familiar with it.
That have a lot of other meaning to it. That has a lot of other meanings because plenty of fish floating around carrying news and none of take it.
A lot of PR has been put into the public domain. And while I'm not, you know, I have no objection to putting it on the record of the Senate or to read it into the record of the Senate or to have it copied and circulated. I don't think it's necessary to put the entire thing. But it has some very powerful points in it which are not in dispute, the truth of which is not in dispute. And the first point that it makes is about the timing of this bill. The submission of this bill in the last few days of the legislative calendar and the lack of consultation with office holders and stakeholders must be of critical concern.
This is coming from the letter from the person from DPP? That is in the letter, or you are saying that?
I am paraphrasing the information in the letter.
Okay.
But the entire circumstances, since we have started, Senator Webby, for example, a number of persons have said, don't focus on the office holder, focus on the office, right? But the entire circumstances begs the question, what is the reason for these rushed amendments in light of the absence of consultations? What is the great mischief and problem that Parliament must so urgently address at this point in time in this rushed manner if it has nothing to do with the office holder? That is the mischief that cannot be successfully responded to because they know what the real truth is. This is all about the office holder. And if it wasn't about the office holder, then there would be no rush to get it through before the thing. But, you know, there is another issue. There is another issue. And the issue is about the separation of powers. My colleague, Senator Lambert Brown, spoke about the co-equal branches of government, the executive, the legislature, and the courts, the judiciary. Now, it is interesting that in one instance that we debated earlier when we were talking about states of emergency, Senator Briam said that it would be a nonsense to declare successive 14-day states of emergency if the Senate did not approve by the required majority the extension of the first 14-day state.
Ronnie said that?
Ronnie said that.
In response to me, Ronnie?
And it was reinforced by the leader of government business.
And then we saw it happen multiple times, immediately after.
So you mean I was right?
So there is now a case before the court, which I'll not comment on further, other than what part of what the case is about is the executive arguing unto itself the power that the Constitution explicitly gave to the Parliament to make that decision. What we are presented here with today, with this bill, is the reverse. What we had was the constitutional process was followed in 2020 when the consultation between the Governor General, the Prime Minister, and the leader of the opposition took place. I believe at the time the Prime Minister had recommended that the DPP be extended to her 65th birthday, as was provided for. At the end of the consultations that took place, and it's in the public domain that the leader of the opposition at the time, the then leader of the opposition, strenuously objected to that extension. The Governor General, at the end of that process, determined to extend for 3 years, not the 5 years originally recommended by the Prime Minister, for 3 years. So now the GG took an executive action and made that determination that 3 years was the extension. So what we're seeing today is a way to bypass the GG's decision by the Parliament, because this is not going to require, well, as we heard from Senator Scott Motley earlier, there was no second extension. There's no possibility, or certainly that's what the learned constitutional experts have said. There's no possibility for a second extension. So what the Parliament has decided now to get around that GG's decision is to bring this bill today and bypass and end run that constitutional decision taken by the Governor General. Right? You will get your chance. You'll get your chance. So we start there. That is certainly an issue that when the constitutional challenge to this bill is brought, that will be one of the issues that will be argued. But if we step back for a little bit, move away from the constitutionality or the legality, and let's just look at the desirability of this extension. First of all, we will now have the likelihood, because as I assume it's really about the office holder, the likelihood of the office holder being there anywhere from 17 to 22 years. 17 to 22 years, one person in this important constitutional office. This goes against all modern thinking that has tended to favor 7-year terms of appointment. I believe we have that in the Governor of the Bank of Jamaica and a number of other appointments that reflect more modern thinking. Why? The 7 years is longer than a political term, but not so long that it creates a diminished sense of responsibility for the office holder. The performance of the DPP has a major impact on the efficiency and effectiveness of the entire criminal justice system. Wields extraordinary constitutional power. So given that reality, shouldn't the Jamaican people have the benefit of the best available candidate being appointed? The best available candidate being appointed to the leadership of this critical office. How do you achieve that? Well, modern best practices requires that such a candidate be identified by the Public Service Commission via an advertised process based on transparent criteria. Why would we be against that? When the extension was done 3 years ago, part of the justification offered was that it would allow for succession planning. But there are other concerns. I have a concern that goes back to when I was chairman of the Internal and External Affairs Commission of Parliament. The committee, I was in the lower house at the time. Because you are a constitutional office holder or any important office, doesn't mean that you should be shielded from public accountability. However, the incumbent DPP, the same one who is there now, then adamantly refused to appear before the Internal and External Affairs Committee of Parliament to submit herself to such public accountability. And you know, study after study has shown that corruption is a major obstacle in Jamaica's national development. And it's exacerbated by the impunity enjoyed by fraudulent and corrupt officials. And we could list a whole series of cases. A whole series of cases, including the UK bribery conviction of Maybe and Johnson. Maybe and Johnson, 2009, that company confessed of bribing Jamaican public officials. Confessed to bribe Jamaican public officials. 2 years later, 2.5 years later, the request for mutual legal assistance had not left the office of the DPP. The office of the DPP has been specifically criticized by the Organization of American States mechanism for the implementation of the Inter-American Convention Against Corruption. They have been criticized by our own Office of the Contractor General for the lack of corruption prosecutions. With this record of performance, it would be a travesty to extend her tenure in such a critical office. But without focusing on the person, just from the perspective of managerial, I'm leaving that aside because everybody else said you shouldn't focus on the person. Then they made arguments in favor of the person. But putting aside the person, just from the perspective, Senator Webby, of managerial and organizational development, 22 years, 17 years is too long for one individual to dominate this constitutional office. Such a protracted tenure robs the office of the opportunity for new thinking and energy, such as we have seen the Chief Justice bring to the judiciary and the administration of the judicial system. But, you know, I can't help but thinking, what about the 5 senior deputy DPPs? Forget the one who wrote this letter. What about the 5? One amongst them who is only the second Crown Counsel to achieve a King's Counsel designation on their own merit. On their own merit. Because we know that once you become the office holder, you get it you get it automatically because you're the DPP or the Attorney General, as the case may be. But there is amongst the 5 deputies persons who are so distinguished that they've earned it, such distinguished prosecutors, they've earned it on their own merit, only the second in the history of the office. Yet, we are going to be complicit in stifling the career advancement of these 5 persons who I feel certain are not going to hang around for another 7 years. Well, we've already heard that more than 50%, of the prosecutors there have less than 5 years experience, because it's unprecedented turnover taking place there. But what we're going to do is to continue to frustrate any attempt at succession planning, any attempt at career advancement, by keeping this individual in place for potentially 22 years. Any principle of organizational management would argue against that. Even you, Senator Webby, I am sure you don't plan to be CEO of Grace Kennedy for 22 years. Nod your head. So, but you know, my final question, because I really think the outcome, given this courageous letter which has been put in the public domain, given this courageous letter that has been put in the public domain, or that is now in the public domain, and I just read one paragraph. For these reasons, I humbly ask that an investigation be launched into the operations of the Office of the Director of Public Prosecution to ascertain its viability at this time, given the massive hemorrhage caused by the constant departure of prosecutors. Furthermore, I also recommend that an objective/anonymous poll be conducted to ascertain from the whole staff whether they are in support of and have confidence in the leadership of Ms. Llewellyn. End quote. End quote. No.
That anonymous, you see, this is what I was saying to you, know. We're in any level of management, right? Because plenty of people, if them take anonymous poll, them wouldn't be anywhere in their organization.
Are you participating in the debate, Mr. President? But I'll be willing to grant you some time in between, but I ask you not to take it out of my presentation. Right?
I'm not taking it out of your time, but I'm just identifying to you how ridiculous it is. Because perhaps if anonymous poll was kept in certain organizations, certain people would be in the leadership of it.
Mr. President, in light of this, we can anticipate those of us certainly who have held senior positions in organizations would understand that if Ms. Llewellyn is reappointed, it is going to be chaos at the Office of the Director of Prosecutions. You are going to have a mass migration of the most senior prosecutors, a mass departure of the most senior prosecutors from that office. And they have options. And they have options. They have options. Better compensating options. But so the question I must ask, and I really would hope, for if anyone has, you know, personal and professional pride, and has a genuine care and love for the office, why would you allow yourself to be drawn through this while you cling desperately to an office in these circumstances? Why would you do that? Why would you do that to yourself? Why would you do that to your office? Why would you do that to the country? And I really hope that the example of General Rocky Meade, when the attempt was made to appoint him as cabinet secretary, and it became clear that the government had made some serious constitutional mistakes or breaches or about to do it, and the debate started, in public domain. He had the dignity to withdraw himself from consideration, to avoid not just damage to his personal reputation, but damage to the office of cabinet secretary. And I really hope that that example, that there are others who will raise themselves to that level. And I hope that those members of the government side, those senators who have that true love for Jamaica, who have that true personal independence, who don't have to be a minister or some government office holder because that's the best option that they have, but who are willing to take a stand on principle and not be complicit in the damage that is going to be done to the law enforcement process in Jamaica by reappointing the DPP. Thank you.
Thank you very much, Senator Bunting. Senator Matthew Samuda, Minister.
Thank you, Mr. President. There are a few times since enjoying the honor and privilege of being appointed to the Senate that I would say I've been disappointed in either the quality of debate or the approach to the debate or the positions taken. And I'm sure colleagues on both sides will have those moments as we invariably are very passionate about the positions that we hold. But when a debate is more around a person and a principle, it is indeed unfortunate. And I have left this discussion and this debate with that certain view, certainly coming off of the last contribution from colleague Senator Bunting, certainly coming from the contributions in the lower house and at their press conference from the leader of the opposition, and indeed from the other contributions. It's personal and it's unfortunate. Mr. President, we shan't be long, but I think there are a few critical points to make. The public watching either here or at home or will watch later need to be very clear that this is not an entrenched provision in the Constitution. That means the government is acting within its right through its administrative authority that it has from being duly elected to manage the affairs of the country in the way that it sees fit. The provision to change the retirement age also has no requirement for consultation. So there's no requirement for consultation. It's not an entrenched provision. And unlike different cycles, and I would say certainly when we would have been on that side, it is unfortunate, because what I've also left today with is that it has confirmed to me, certainly since 2016, that the opposition still wants to govern from the opposition benches, as opposed to allowing the government to proceed as per its mandate from the people, and proceed we will this afternoon. Invariably, we're all unelected and appointed in this chamber. Some of us faced the electorate and it didn't work out, but that's a different matter altogether. But for another point that I think needs to be widely understood, because we're talking about polls and who knows the mood of the people and who has the understanding of how people feel. I guarantee you that if you poll the members in this house, in the lower house, outside, anybody...
A secret poll.
Secret or public, it's not an issue. If you poll Jamaicans, regardless of their political involvement, their following of current affairs, and you ask them, well, what is the Constitutional Reform Committee about? And they may articulate it differently depending on who they see, but they would largely come to the agreement that it is about Jamaica's identity. It is whether we want to have a foreign head of state or whether we want to have a local head of state, whether we wish to be a republic or not. That is the gravamen of the work being undertaken by that committee. This provision was never contemplated to be considered in this phase, and there is no need for it to be. The other point I think that needs to be rebutted and understood, because it was raised by Senator Brown in relation to Minister Chuck's comments and the Gleaner's coverage of it. Minister Chuck corrected one single point. In his presentation, Minister Chuck mentioned that the Ministry of Finance had it for 2 years. In his correction, he said it started in May. Right? That is the only correction made as opposed to what he would have said earlier. Now, when we look at respect for the Jamaican people, it is this side that has shown it. Don't be misled if you're watching at home by the utterances of colleagues on the other side. It is that side and their leader that had to apologize for homophobic comments. It is that side that had to apologize for calling Labourites damn fools. It is that side that had to withdraw comments on dead voters when they realized that it is a breach of ROPA, and in breaching ROPA, it is also a breach of its constitutional position. You know, so no consultation required.
President, there's a point of clarification. No, I need a point of clarification. Is that the reason why the Prime Minister couldn't go through the normal protocol?
Senator Brown, Senator, continue, please.
Sit down, Senator Brown, because you know that is nonsense. Mr. President, beyond that discussion, the level of hypocrisy being displayed when you have members of this chamber who know that their position is to review law, questioning the extension of a retirement age of the person who would prosecute someone who breaches the laws we review, who are over 60, questioning the extension of the time is ridiculous. It is further hypocritical when this chamber approved and supported the extension of the retirement age of High Court judges and indeed judges on the Court of Appeal. And for persons to recall, to show you how the structure of government sees them similarly. They even get there even in the same pay scale, to show you that the system and the state sees them similarly. Beyond that, President, we all agreed in 2017, when we started discussing the pensions issue, that we could not afford to lose good experience. It came from both sides of the aisle. Now, because it has been personalized, the point has to be made. The experience of the office holder that, quite frankly, has been unfairly attacked by the opposition is one where she has fearlessly and fiercely prosecuted cases of corruption on both sides of the aisle. That is a fact. And one wonders, Mr. President, why this side has no objection to the learned DPP doing her job, despite not always agreeing with everything that she says, despite her being lead prosecutor on cases that have to do with members and former members of the party. But one wonders, Mr. President, if this fascination and this deep-seated attack on the office holder that has come is because of the prosecution of Crying Kern and indeed Trafigura. Mr. President, comments were made by the leader of opposition business in the Senate. Mr. President, so he was guilty? That's what you're saying? Anyway, because of what? What you just said? Because he was guilty? Okay, no problem. Mr. President, comments are being made. Comments were made by the leader of opposition business about reports on the office. But he should recall that he has been victim of reports also from time of the Contractor General with issues with the Integrity Commission. And indeed, no, I'm certainly not. No, and I would suggest to you, I would suggest to you that international reviews of the same situation will be very interesting soon. However, as I started, it's unfortunate that instead of sticking to principle that we established when we extended the age for pensions, that we established in this Senate when we extended the age for High Court judges and for judges on the Court of Appeal. Instead of sticking to those principles, we have personalized a matter because of what appears to be personal vendettas. We have jumped into a discussion of what I view as clearly a very personal, disgruntled employee. Mr. President, this matter should not have had to be debated in this manner. It is a disgrace. And on that note, Mr. President, I ask that Mr. President, that the bill be read for a second time.
Thank you very much, members. The question is that the bill be read for a second time. Those in favor?
Divide.
Let's just do this thing right now, please. You have to say, first of all, you say yea or nay, and then you call for the divide. Okay? Divide is not a vote. The question is that the bill be read for a second time. Those in favor?
Nay. Divide.
Madam Clerk. Senator Fraser Binns, you showed Scott Marty the thing.
Senator Allen, Senator Braham, Senator Bunting, Senator Brown, Senator Crawford, Senator Fitz-Henley, Senator Fraser Binns, Senator Gale, Senator Golden Campbell, Senator Hill, Senator Johnson Smith, Senator Dr. Longmore, Senator Dr. Floyd Morris, Senator Dr. Dana Morris Dixon, Senator Gabriela Morris, Senator Samuda, Senator Scott Motley, Senator Sinclair, Senator Webby, Senator Williams,
The members would have recalled the question asked us whether the bill would have been read for a second time, and I do report as follows: 11 ayes, 7 noes, with 2 absence. So therefore, the bill will be read for a second time.
A bill
Just
entitled
President,
an
just
act
before
to
you get
amend
to
the
that.
Constitution.
1 minute, Senator.
I believe the true vote would be 7, but Senator Morris is not present. And so we don't want to be padding the vote. Come on, what? It is 6.
Madam.
6, not 7. And I therefore do not wish an error to be recorded I do not wish an error to be recorded in the records of the Parliament. It is 6 on this side at the moment. But if Janice and Floyd was here, it would be 8. So I apologize. If somebody on that side voted no, I apologize.
No. Yes. This is, you know, that it's so interesting because we're having this very debate in the Standing Orders Committee. And what had happened is that there was a error in the calculation, but as the clerk pointed out today, there are 3 calculations which are used, and all she did was just consult. So, Senator Brown, I regret to say that you are perfectly correct. So the record of the vote is as follows: 11 ayes, 6 noes, and Madam Clerk, the bill is to be read for a second time.
A bill entitled an act to amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General, and for connected matters, read a second time.
Thank you very much. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause, of which there are 3. I put clause 1. Those in favor?
Amendment to 1, President.
1 minute.
Chairman.
1 minute. So I put clause 1.
An amendment.
And 1 minute, Senator Brown. There is a proposed amendment to clause 1 by Senator Brown. Senator Brown?
Good. At the end of the sentence, ending on all amendments thereto, I wish to propose the following: that the effective date of this amendment be the 2nd of January, 2024.
Mr. Chairman.
I'm going to put it. The amendment proposed by Senator Brown is that after the words "and all amendments thereto," clause 1 be amended to read, "and all amendments thereto," full stop, to take the effective date to be the 2nd of January, 2024. So you change it, you know. You just want to be perfect. So the effective date of this amendment shall be the 2nd of January, 2024, correct? Members would have heard that proposed amendment. Those in favor?
No.
Okay. Well, that amendment is not carried as the noes have it.
We say yes on this. Yes.
There is a call for a divide. Madam?
Senator Allen? Senator Braham? Senator Bunting? Senator Brown? Senator Crawford? Senator Fitzhenley?
No.
Senator Sophia Fraser Beans? Senator Gale?
No.
Senator Golden Campbell? Senator Hill? Senator Johnson-Smith, Senator Dr. Longmore, Senator Dr. Morris, Senator Dr. Morris Dixon, Senator Gabriela Morris, Senator Samuda, Senator Scott Motley, Senator Sinclair, Senator Webby, Senator Williams.
Thank you very much. So that vote and subsequent divide was, was in relation to the proposed amendment put by Senator Brown. And in this regard, there are 6 ayes and 11 noes. There are 3 senators absent, so that the noes have it. So I'll now put clause 1 as it stands in the bill. Those in favor? Against? Ayes have it. I put clause 2.
Amendment to clause 2.
Amendment proposed to clause 2 by Senator Brown. Could I have the amendment, please, Senator Brown?
I'm proposing that after subsection 2, a new subsection 3 be introduced, and just for completeness, I'm going to make the same proposal in the 3rd clause, and these are the wording. Notwithstanding, notwithstanding anything in subsections 1 and 2, this amendment does not apply to the current incumbents. This clause does not apply to the current I want to add a 3. Does not apply. It does not apply to the current incumbent office holders.
Members would have heard the proposed amendment by Senator Brown, which reads as follows. Notwithstanding anything in subsection 1 and 2 of this Act, the amendment does not apply to the incumbent office holders. That is the proposed amendment. Those in favor? Those in favor? Those against? Okay, there is a call for a divide again. Madam Clerk?
Senator Allen, Senator Braham, Senator Bunting, Senator Brown, Senator Crawford, Senator Fitzhenley,
No.
Senator Fraser Beans, Senator Gale, Senator Golding Campbell, Senator Hill, Senator Johnson-Smith, Senator Dr. Longmore, Senator Floyd Morris, Senator Dr. Morris Dixon, Senator Gabriela Morris, Senator Samuda, Senator Scott Motley, Senator Sinclair, Senator Webby, and Senator Williams.
In relation to the proposed amendment by Senator Brown, there are 6 ayes, 11 noes, and 3 members of the Senate absent. So the noes have it. So I now put clause 2 in the form in which it appears in the bill. All in favor? Against? I put clause 3.
Amendment to clause 3 being proposed.
Yes, sir. Go ahead.
As I indicated earlier, the same amendment, same wording. So there'll be a 3-3 with the wording that I just used at 2.
Members would have heard that. Do I need to go through it? Yeah, but if you don't answer, I can't know. I don't read. Yes, and so it would read, notwithstanding anything in subsection 1 or subsection 2, this amendment does not apply to the incumbent holder of the office. That's essentially it. Those in favor? Against? Against? Thank you. So the noes have it unless there is a divide. Okay. Thank you very much. So
divide. Just do the divide and let's move on.
Are you calling for a divide?
Yes,
Go
sir.
ahead, please.
Senator Allen, Senator Braham, Senator Braham, Senator Bunting, Senator Brown, Senator Brown, Senator Crawford, Senator Fitzhenry, Senator Fraser Beans, Senator Gale, Senator Gordon Campbell, Senator Hill, Senator Johnson Smith, Senator Dr. Longmore, Senator Floyd Dixon, Morris, abstain. Senator Dr. Morris Dixon, Senator Gabriela Morris, Senator Samuda, Senator Scott Motley, Senator Sinclair, Senator Webby, Senator Williams.
In relation to the amendment put by Senator Brown, the result is as follows. 6 ayes, 11 noes, 1, 2, 3 members of the Senate absent, so that the noes have it. I now put clause 3 as it appears in the bill. Those in favor? Against? I put the title and enacting clause. Those in favor? Against? The question is that I do. The question is that I do report the bill as having passed. The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Against? I do report the bill as having passed committee stage without amendment. Mr. Samuda?
Mr. President, I now ask that the bill be read a third time.
Those in favor? Against? Madam Clerk.
A bill entitled An Act to Amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General, and for connected matters read a third time and passed.
Mr. Leader.
Mr. President,
here you go.
Given that we have no more business to be conducted today, and we do not intend to conduct any such business today, we ask that the House be adjourned for a day to be, the Senate to be adjourned for a day to be. Thank you very much, Mr. President.
What is clear, thank you very much, Minister Hill. What is clear is that for the month of August and September, as this chamber will be undergoing some much needed repair stroke renovation, I will not be meeting here. I want to just take I want to just take this opportunity to thank the clerk, all the staff, the assistant clerk, the deputy clerk is away on government business, but I thank her, the acting assistant clerk, all the members of the chamber staff, the marshal, of course, it's our security, Hansard, members of the press who put up with us prattling on for hours on end, hoping to get but one gem that they can report. All the orderlies, of course, and the persons who work here in the as technocrats, the legal officers, and all the persons who work here. Wish you a happy independence, emancipation, independence period, and urge members of the Senate, I know you want to take a little holiday, but I urge you to participate in some of the programs that have been organized on a national level. Oh, well, in no doubt in due course you will be given passes, but participate in the program and enjoy the season, and most importantly, keep yourself safe so that you can come back with a fresh, agile mind when the Senate resumes. The question is that the Senate be adjourned for a date to be fixed. All in favor? Against? This Honorable Senate now stands adjourned for a date to be fixed.